Okay. No worries. All right, we're back on the record on State versus Loyd. Mr. Loyd's present with his attorneys. State Attorney's Office is present. Mr. Loyd has changed shirts. He's now wearing a blue button-down long-sleeve shirt, civilian pants. He's still wearing the shackles and the jail shoes, but his feet are underneath the table and cannot be seen by the jurors from anywhere in the courtroom. All right, back to jury questioning. Let's bring in juror in seat number 55, please. Good afternoon, ma'am. How are you?
I'm doing well, thank you.
How was your lunch?
Good, easy.
Good. All right. Sorry, this case is it's serious. We have to take our time with this, so
Of course.
just bear with us. I have a few questions for you. There aren't any right or wrong answers to the questions. It's very important that we know jurors are able to do their jobs. So if you'll just answer the questions truthfully and fully, you'll be doing exactly what you're supposed to do, all right? Let me start with, you said you knew something about this case. What is it that you know?
Just very simply what was in the headlines a while back and what's been on the news, and that is that jury selection is underway, and they expect it to take a while to get that figured out, and that's really it.
Okay. So the newscasts that you listened to and the headlines that you read, they were recent?
Within the past month, anyway.
Okay.
Yes, ma'am.
Prior to that, had you heard or read anything about the case?
The only thing that I can recall is just reading about the police officer being shot, that the case was underway.
Okay. And so, based on everything, have you formed an opinion as to whether or not Mr. Loyd is guilty?
I have not, Your Honor.
All right. Let's talk about the death penalty a little bit. Do you have any religious, moral, or personal objections to the death penalty?
I do not.
Okay. Are you someone who believes that if a person is convicted of first-degree murder, which is the intentional killing of another human being without legal justification, that if someone is convicted of that, they should be sentenced to death?
If it is beyond a reasonable doubt, and if that's what the law states should happen, then yes.
Okay. Let me break that down in two pieces. All convictions in the state of Florida for criminal cases must be beyond a reasonable doubt. So in the guilt phase, when the jury's trying to decide whether or not Mr. Loyd's guilty of these, unless he's convicted beyond a reasonable doubt of first-degree murder, the intentional killing of another human being, you don't move on to the penalty phase. You follow me so far?
I do.
All right. And as I told you all, we don't have an automatic death penalty in the state of Florida. The regular sentence for first-degree murder is life in prison without the possibility of parole. In order for death to become a possibility, a possible sentence, the state has to prove at least one aggravating factor beyond a reasonable doubt. Okay? That's done at the penalty phase that I was talking to you all about, second phase. So if they don't prove an aggravator beyond a reasonable doubt, death isn't even a possible sentence. But assume that one was proven. The defense has mitigators that they want to prove up. Theirs are proved by the greater weight of the evidence. It's a lower standard. But those mitigators are why they believe the verdict should be for life without the possibility of parole. And they can be anything. Like I said, they can relate to the defendant's character, his background, the circumstances of the crime, pretty much anything, okay? At the end of that penalty phase where you've gotten the state's evidence, the defense's evidence, I'll give you the instructions on what you're supposed to do. But fundamentally, you're going to go back in that jury room. You and the other jurors can talk about this as much or as little as you want. But in the end, you have to make an individual decision. So you're going to be weighing aggravators and mitigators. And by weighing them, we mean you're going to determine what importance you feel they have in you making a decision. And that's completely up to you. You may find an aggravator is very important, or you may find a mitigator is very important, that really factors into your decision. You can reject them. You can say, I don't believe this, whether it's a mitigator or an aggravator. It's totally up to you. Once you've done all that weighing and you have all the other evidence and facts that you've heard throughout the trial, then at that point you have to make a decision, ma'am, as to whether or not you believe the verdict should be life without the possibility of parole or death. So if you went through that whole process and it led you to believe that life without the possibility of parole was the appropriate sentence, could you vote for that?
Yes, Your Honor.
And same thing if it led you to believe it was death, could you vote for that?
Yes, Your Honor.
If the conviction here, well, the first count involves the death of a law enforcement officer. Do you believe you could still go through that process I just told you about, even if you found someone guilty of intentionally killing a police officer?
Yes, Your Honor.
All right. Could you consider life as a possible penalty in that situation? Or would you automatically vote for death?
I would not automatically go for death.
Okay. Let me move on to the insanity defense. As I told you, it's been raised in this case. So this is in the guilt phase, the first phase of the trial, when you all are trying to decide whether or not Mr. Loyd is guilty. This is the one time in guilt that the defense has the burden. They have to prove insanity by clear and convincing evidence. Assume it's the end of the guilt phase. The state's put on all their evidence, the defense has put theirs on, and you believe that they have proven insanity. Would you be able to return a verdict of not guilty by reason of insanity?
Yes, Your Honor.
All right. And then my last question to you is this. Remember, I told you that Mr. Loyd's already been convicted of murdering Miss Dixon and her unborn child, and he was sentenced to life without parole in that case. So you can't use that in the guilt phase of this case. In other words, you can't say, well, he killed her, so he must have done this. All right? Forget that in the guilt phase of this case. Can you put it aside and just render a verdict based on the evidence about these crimes? All right. Thank you, ma'am. I don't have any other questions for you, but I'm sure the attorneys do. Mr. Buxman, you may inquire.
Thank you. Good afternoon, ma'am. I noticed in your jury questionnaire that you had been a juror before.
Yes, sir.
Was that here in Orange County?
It was not. It was in North Carolina.
About how long ago?
It was approximately 4 to 5 years ago.
Do you remember if it was a civil or a criminal case?
Civil.
Okay. Without telling me the verdict, were you able to reach a verdict after deliberating?
Yes, we were.
Okay. And were you the foreperson of that jury?
Yes, I was.
All right. Is there anything about that experience that just makes you not want to do this process again?
No, sir.
Okay, that's good to hear. Consider it a decent experience?
Yes.
Okay. I'm going to ask you a few questions touching on some of the issues the judge just went through with you. She explained to you that in this case, the death penalty, in any case, the death penalty only becomes an issue if the jury finds beyond a reasonable doubt that the defendant committed first-degree murder. Does that make sense?
Yes.
And regardless of how the murder was committed, how premeditated it was, how egregious it was in your mind, there still has to be a separate sentencing phase where additional evidence is presented called aggravating factors and additional evidence regarding mitigating factors. That is presented to a jury before a jury make a final decision of what the proper punishment is. Do you think that process is fair, to have a separate proceeding where additional evidence is presented to determine the proper punishment?
Yes, I do.
So can you agree to withhold judgment if the jury finds the defendant guilty of first-degree murder? Can you agree to withhold judgment as far as what the proper punishment should be, no matter how bad you think this murder was when it was committed, until you hear this additional evidence?
Yes.
Okay. If this case gets to a penalty phase, the state will present aggravating factors, which are factors that make this murder more egregious than other murders. Can you also agree that regardless of how many aggravating factors are presented to you, regardless of how egregious you think this murder was, that you could again withhold judgment of what the proper punishment should be until you hear all the mitigating evidence?
Yes.
Okay. This is not the time to talk to you or tell you the specific pieces of evidence or the details of what aggravating factors will be presented to you or what mitigating factors are going to be presented to you. That will be during the trial. appropriate to talk to you about those here. But can you keep an open mind and consider any and all mitigating evidence or evidence that is presented by the defense to suggest that life is the proper punishment in this case? Can you keep an open mind and listen to any and all mitigating evidence before making your final decision?
Yes.
Okay. Do you think that Mr. Loyd is entitled to have a jury that will keep an open mind and consider all that evidence before making a decision?
Yes.
Would you be able to keep an open mind even if when first presented, a piece of mitigating evidence is presented to you, and at first blush you might think, I don't know if that's mitigating. You hold off judgment until you hear all the details surrounding what that mitigating piece of evidence is.
I believe I can.
Okay. So if I stood up here and went through 100 different potential mitigating pieces of evidence, can I assume that your answer would be always, yes, I would consider it before making a final decision?
I can.
Okay. Now, once you get this information and the pieces of evidence surrounding the aggravating factors and mitigating circumstances, you have a couple choices of what you can do with that. You can look at the evidence and say, I don't think this aggravating factor or mitigating factor has been proven. And if you don't think it's been proven, you can ignore it. Or you can say, it's been proven, but this piece of evidence really isn't important in my decision-making process, and give it little weight or no weight. Or you could say, this piece of evidence is really important in my decision-making process, and I think it's very, very weighty, so that when I use that piece of evidence to consider what the proper punishment should be, that piece is important to me. That make sense? Okay. Once you go through that assigning importance or weight to all the evidence, if the jury determines that the aggravating factors outweigh the mitigating circumstances, then the death penalty is a possible punishment. Does that make sense?
Yes.
Okay. If the proper punishment in this case is an individual determination for you as well as all the other 11 jurors that would be with you. If one juror decides that life is the appropriate punishment, that becomes the sentence in this case. It would take all 12 jurors to say the death penalty is the appropriate punishment for that to become a potential sentence. You with me?
I am.
Okay. If you felt, after analyzing all the evidence and weighing all the aggravating factors and mitigating factors, that life was the appropriate punishment, could you come back here and say, I think life is the appropriate punishment and vote that way?
Yes.
On the other side, if you felt in your heart that the death penalty was the proper punishment, could you again raise your hand and vote to impose the death sentence on another human being in this case?
Yes.
Any concerns about your ability to do that? Looking into yourself, not talking hypothetically with friends and coworkers, but you sitting in that position.
I think that's always a challenge, but I think it's the right thing to do. Yes.
If the evidence supports it.
If the evidence supports it.
Okay. Touching real quick on the insanity issue the judge mentioned. I'm going to ask a couple personal questions, and I apologize, but you can probably see why I have to ask that. Do you, or a close friend or family member, have any experience with a mental health issue?
No, sir.
Okay. Some people in our society may think that mental health issues are just made up, fake excuses to justify your actions. I'm assuming you're not one of those people, are you?
No.
So do you believe that mental health issues are in fact real and affect people in society?
Yes.
Would you be able to listen to all of the evidence surrounding the insanity defense and the mental health issue and decide if there was a mental health issue in this case, and if so, what impact it had before making a decision as to whether insanity is proven?
I think that's the right thing, yes.
Is there anything in your background or your belief system that makes you think maybe I'm not going to be a good juror for this type of a case? Anything?
I don't think so.
Great. Your Honor?
Yes, sir.
Thank you, ma'am. I have no further questions, Your Honor.
Thank you, Mr. Buck.
Thank you.
Ms. Miller, you remain quiet. Sorry. The defense has a chance. All right.
Thank you.
Hello. I want to back up a little bit and just ask you a few clarifying questions, if that's okay. So we're on the same page. First-degree murder in Florida is defined as the intentional, premeditated killing of an innocent human being. That defendant thought about it, meant to do it, and he did it. And if a jury found somebody guilty of the intentional, premeditated killing of an innocent human being, that jury would have considered any available defenses, like self-defense, and would have rejected any of those defenses and found that that murder was committed without legal justification, excuse, or defense. With me?
Yes.
Is death the automatically appropriate penalty for that guilty murder in that scenario?
In that scenario, I would say yes.
Okay. Tell me why you say that.
Well, if it's conscious decision of knowing what you're doing and you're doing it, if there's no question about it, if I understood your situation correctly.
And that's why, there are no right or wrong answers here. Some people feel very strongly in favor of the death penalty, some not so much, right? And it's just figuring out what your truth is. And so that's why the judge went through the process of explaining how a juror might be able to vote for death or what makes somebody eligible. And some people say, yeah, I can follow that process. And some people say, I feel very strongly that once someone is found guilty of the premeditated intentional killing of an innocent human being, for me, I hear that process, but death is really the appropriate penalty. Does that describe you?
Not necessarily.
Well, tell me what you mean.
Well, so I'm thinking about the discussion about, is there an insanity defense? And I don't know if that factor the doctor or psychologist, I don't know somebody's thinking. So there's this part of me that goes, it may not be that automatic, yep, that sentence is right thing. I don't know that I have that information.
I hear you. Let me see if I can break it down a little bit.
Okay.
Not guilty by reason of insanity is a legal defense. That's the first part, right? So in this first part of the trial, the jury decides if the defendant is guilty of the crime of capital first-degree murder beyond a reasonable doubt. The state has to prove all of the elements and that the defendant is the person who committed that crime beyond a reasonable doubt. With me? Similarly, that defense of not guilty by reason of insanity would be something that would be raised in that first part. If you found that the defendant was insane, he would be not guilty, so we wouldn't even get to the second part. Does that make sense? And so that's why we're talking about, let's just assume for the purpose of this conversation that this defendant we're talking about is guilty of the intentional premeditated killing of an innocent victim without any excuse, justification, or defense. So if you found somebody guilty, you've eliminated the possibility of any of those defenses. And so for you, is death the appropriate penalty automatically once you've convicted somebody of that intentional premeditated killing?
Well, the discussion about the litigators and aggregators, I'd like to understand that better before I form.
Okay, and that's where only you know what's inside you. Some people say, yeah, I think I could do that. And some people say, no, this is a deeply held belief that I have, that if somebody is guilty of murder, death is really the only appropriate penalty for me. And so I'm trying to figure out where you are in that spectrum. So yes, in order to sit on this jury, all jurors must be able to give meaningful consideration to both penalties. And some people say, I can do that. And some people say, I don't think I can because of this deeply held belief. And that's okay too. It's just trying to figure out what's your truth. So where do you think you are in that?
Well, I do believe that everybody is accountable. And as a Christian, the Bible speaks to being accountable to the line for a time. However, yeah, it comes down to discriminators. And I don't have to be accountable today. No, assign the death penalty in my mind, nor do I have a strong, yes, I absolutely could without any question. It's hard to answer that question.
And I'm not trying to press you or give you a hard time.
Understood.
Obviously, this is a very big deal.
Understood.
And this is our only time, right? We may not even get to the second part of that trial in Mr. Loyd's case.
Correct.
Right? But this is the only opportunity I have to speak to you, and the law requires us to have this conversation now.
Of course.
I want to ask you when the judge spoke with you, your answer was, if it is beyond a reasonable doubt and that's what the law states should happen, then yes, that's imposing the death penalty. What were you thinking when you answered that way?
I guess I was a little bit confused between the two phases. So that first phase, if it's guilty beyond a reasonable doubt, you automatically move into that second phase. And within that phase is where I would need to make that decision again based on what those mitigators are, what those aggravators are, and where they weigh in my mind.
Okay.
Did I answer your question?
Yes, I think so. Let me ask you a little bit differently. If you have found someone guilty of the intentional premeditated killing of an innocent victim without legal excuse, justification, or defense, would you say you're kind of starting out thinking the death penalty is deserving in that case, and then either myself or one of my colleagues is going to have to convince you of why life should be the appropriate penalty?
I would say yes.
Okay. Let me ask you, the same circumstances still exist, intentional premeditated killing, but the innocent victim is a law enforcement officer. Is death automatically the penalty once you find someone guilty of the intentional premeditated killing of a law enforcement officer without legal excuse, justification, or defense?
I would say yes.
Okay. And if, another factor, all of those things still true, that defendant that we're talking about for this murder of a law enforcement officer has been previously convicted of another murder and is serving life without the possibility of parole, is death the automatic appropriate penalty for this killing of the intentional premeditated killing of a law enforcement officer?
I don't at first impacts the second.
Okay.
Does that make sense?
Sure. Some people say, yep, I know he's serving life. That's going to impact this sentence. I'm just trying to figure out where you are. Okay. And then
Rationale, just to clarify, that would not be my rationale, saying that.
okay, but still with the law enforcement officer.
Right.
Okay. And the state talked about, would you be able to consider mitigation? And you said yes, of course. Let me ask you about a specific one. The effects of racism. And when, again, you seem like a very thoughtful person. I don't think you're going to sit there and ignore anything. The question, though, is would you meaningfully consider it? It is something that could potentially compel you one way or another, right? The effects of racism on the defendant. Is that something you believe you could give meaningful consideration to? Okay. You can appreciate that 12 people may feel differently about things like whether someone lives or dies. Yes?
Yeah.
And there's 12 jurors that are seated in this case. And that death is never required, not in any case, not in this case, not in the worst imaginable case you can conceive of. With me? If one person decides that life should be the verdict, then life will be the verdict. Okay with that? Yes. We talk about mitigation. It's a legal term. Why one person would choose life or not choose death. Okay? And it doesn't have to be unanimous. It is unique to each individual juror. So one juror may say, I find it mitigating just a smile I observed between the defendant and a family member. And for me, I'm going to assign that the weight of life. And that could totally not matter to you, but it's okay. The law contemplates that.
Right.
Okay?
Yep.
And sometimes these things can get a little contentious, right? Because people have strong opinions. But in order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies, those moral assessments have to be heard in this courtroom. And so the foreperson, signs the the verdict form, but the foreperson's job is to reflect that all 12 people's individual moral assessments are reflected on that verdict form.
Understood.
And you're not going to bully or badger anyone to agree with you. Right.
Correct.
And you wouldn't allow somebody else to do that as well. May I have just a moment, Your Honor? Here. I gotta turn around. Okay.
Let me see the attorneys at the bench. We'll be right with you, ma'am. Ready? Okay. All right, ma'am. I want to thank you, we all do, for your time and attention and your willingness to serve, which we really appreciate. I'm going to excuse you as a juror in this case. You are free to go.
Thank you.
All right, that was all of the jurors who had heard something about the case, or told me they did. So going back to the juror in seat number, is 4 coming at 2? No, juror in seat number 4. It's 7 and 24 coming at 2, right? Okay. Juror in seat number 4, please. All right, good afternoon. How are you?
Good, how are you?
I'm well, thank you. So we're going to be asking you some questions today. I'm going to start, then the attorneys are going to have a chance to talk to you. All right. There aren't any magic answers here. There's no right, there's no wrong. It's very important that you be honest and open with us and answer the questions as truthfully as you can and as honestly as you can. If you don't know, just say, I don't know, okay?
Okay.
So let me start with this. I'm just confirming that you've never heard anything about this case prior to coming here?
No, never.
All right. So do you have any religious, moral, or personal beliefs against the death penalty?
I really think it's like, in order to get
Okay,
the death,
you got to hold that mic near, there you go.
in order to get the death penalty, you need to do something like very bad in my eyes. Like taking many lives, or just doing something really bad. I think that would really need the death penalty, but it all depends on what it is.
All right. So as I was explaining to you all, the law in the state of Florida is there's no automatic death penalty for any first-degree murder conviction, all right? And first-degree murder is intentionally killing another person without any legal justification. I mean, you don't have a defense. It's not self-defense. It's not anything. You had no legal right to kill this person, and you did it intentionally. You understand that? Okay. Until there's a conviction on first-degree murder, the issue of the death penalty doesn't even come up. Do you understand that? And the conviction has to be to a standard that we call beyond a reasonable doubt. You follow me so far?
Yeah.
Okay. So once that's occurred, then we get to the penalty phase, phase 2. Now's when the jury is going to hear testimony and evidence about what sentence would be appropriate in the case and vote on that. The state, these gentlemen right here, are required to prove what's called an aggravator. There are statutory reasons. Let me back up a little bit. The automatic sentence for first-degree murder in the state of Florida is life in prison without the possibility of parole, unless the case meets the standards for a death penalty, which require at least one aggravator. It can be more, but you have to have at least one aggravator that is proven beyond a reasonable doubt by the state. You follow me so far?
Yeah.
The defense then presents mitigation, which are the reasons they believe the vote should be life without the possibility of parole. The jury has to decide, after weighing the aggravators and the mitigators, has to decide that they believe, by a unanimous vote, that death is the appropriate sentence. And weighing an aggravator and mitigator is done individually. You all can talk about it. We welcome you to talk about it. But in the end, it's your individual vote. And you may find one aggravator very important and another one not important at all. You may look at all the mitigators and say, I find these 3 important, I don't believe these. But when I look at all of this, I think these mitigators are more important to me than these aggravators, and I think the sentence should be life without the possibility of parole. You with me so far?
Yes.
All right. Again, you may look at all this and say, look, I believe all these mitigators exist, but to me, these aggravators outweigh that, and I think the sentence should be death. All right, so if you went through that process and you thought the sentence should be death, could you vote for death?
It's very it's a sensitive topic. I don't know if I if I have the gut to do that. It's really hard to just
Okay.
send someone to death, but I'm not sure if.
It's not supposed to be easy to
Yeah.
vote on any of this, all right? You're supposed to take it very seriously. It's a very serious decision. But in order to be able to sit as a juror in a case like this, you're never required to vote for death. The law doesn't say, well, even if you think death is the right sentence, you have to vote for it. But the law does say that you have to be open to it and you have to be willing to vote for it if you think that's what the sentence should be. The same with life without the possibility of parole. If you think that's what the sentence should be, you have to be able to vote for it. You can't automatically vote one way or the other. Do you understand that?
Yes.
All right, so again, take a minute and think about it. Do you believe that if it all led you to a death sentence, could you vote for that?
I think so.
You think so?
Yeah.
You have a little bit of doubt?
Yeah.
Is the doubt because it's a death sentence?
Yes.
Okay. So, is there any case where you would, before you heard anything, you would just think, if I convict him of this, I'm voting for death?
Repeat the question.
Is there any, in any case, where if you heard, where you were thinking, before the case started, you were thinking, if I find this person guilty of this first-degree murder, of intentionally killing this person without any legal justification for it, I'm going to sentence them to death? Is there any case that you can think of that falls into that category?
I don't think so. No.
Okay. And that's what we mean by there is no automatic penalty in the state of Florida. You first have to find someone guilty of first-degree murder, intentionally killing someone without having any defense to it. There's no legal reason why you did this, all right? Before you can even consider death. But what we're asking you is there anything, any case at all, including the murder, this case would be conviction for the murder of a law enforcement officer. Would that alone get you to think, if I find him guilty of this, I'm gonna vote death, I don't care what anybody says?
It really depends on how I guess is how many people they've killed.
Okay, well, that would be an aggravator.
Yeah.
Okay?
Uh-huh.
So again, the state has to prove to you, once it's been proven that this was an intentional first-degree murder, they then have to prove to you the existence of aggravators, which are the legal basis for taking a case from a life sentence to a death sentence. That's a different question than what I'm asking you.
Oh, okay.
My question is, when you started the trial, if you were going to start the trial tomorrow, would you automatically be thinking, if I convict this person of murdering a police officer intentionally, I'm voting for death?
No.
Okay. Same thing about, is there any case where you would say, I don't care what anybody says to me, if I convict them of this murder, I'm not voting for death? I'm automatically voting for life. I don't care what the facts are.
Yeah.
No?
No.
All right, so you could consider both life and death.
Yes.
You remember I told you that Mr. Loyd has already been convicted of the murder of of Sade Dixon and her unborn child, all right?
Yes.
She was pregnant at the time, and he was sentenced to life without the possibility of parole. At the beginning of the case, hearing nothing else, is there anything about that fact that would cause you to say, if I find him guilty of first-degree murder, I would automatically sentence him to death, having heard nothing else?
No.
So are you willing to consider all the aggravators and all the mitigators in this case
Yeah.
and weigh them as you believe is appropriate? Give them whatever importance you believe is appropriate.
Yes.
And you're not going to are you going to sit there with your arms crossed saying, yeah, I'll listen, but I'm not really listening, I'm just waiting to vote?
No.
All right. The defense of insanity, remember that I told you Mr. Lloyd's raised that?
Yeah.
That's in the guilt phase, when you're trying to decide whether he's guilty or not. It's the defense's burden to prove insanity. It's the only time they have a burden to prove something in the guilt phase. They have to prove it by clear and convincing evidence. So if at the end of the case, you've heard all the state's evidence, you've heard all the defense's evidence, and you're convinced that that they proved it and he's not guilty by reason of insanity, could you return a verdict of not guilty by reason of insanity?
Could I return that? What does that mean?
Meaning, could you vote not guilty by reason of insanity?
No.
Okay, can you tell me why not?
Like, so if they said that he's guilty of insanity,
They have to prove it.
yeah, and they don't prove it.
No,
Is
if
that
they
correct?
do prove it.
They do prove it.
Yeah.
I'm still like trying to like wrap my head around it.
These are legal concepts that are difficult, so tell me what you don't understand.
The question where like the insanity question, so if they prove that he is insane, what was the question for like?
The question on the verdict form would be, do you find him to be not guilty? It's a little more complicated than this, but I'm going to simplify it for you. Do you find him to be not guilty? Do you believe that the defense has proven by clear and convincing evidence that Mr. Lloyd is not guilty by reason of insanity? So if your answer was yes, could you check the box yes?
Yes.
Okay. I understand nobody's proven anything. We're just asking you whether you could do this. Do you have any doubts about your ability to find someone not guilty by reason of insanity if they prove they were insane? You
Yeah.
could do that?
Yeah.
All right. I don't think I have any other questions for you, but the state has some questions for you, and then the defense will. Mr. Buxman, you may inquire.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
When you and the judge first started talking about your views on the death penalty, I think you said, and if I'm incorrect, please tell me, something to the effect of if the death penalty is appropriate if someone did something really bad, like killing many people. Did you say, am I correct?
Yeah.
Okay. Is that the situation that first popped into your mind when she mentioned the death penalty?
Yeah.
Okay. Do you feel that the death penalty is appropriate only for somebody who's killed many people?
I think so, yeah.
Okay. Would you be able to vote for the death penalty if the evidence supported it, if only one person was killed?
I'm not sure, no.
You have a reasonable doubt in your mind whether you
Yeah.
could do that? Okay. Now, I think the judge also told you that the death penalty, a vote for the death penalty is never required by law. You understand that?
Yes.
It's always up to you as an individual juror to make that decision. Okay. Now, earlier you said you were hesitant about whether you would be able to actually vote for the death penalty.
Yes.
Okay, and for purposes of this question, we're not talking about you hanging out with your friends, you talking with coworkers, seeing something in the news saying, oh, I could vote for death on that. We're talking about you in a real life situation being the one to cast your vote.
Yes.
You seem to have a pretty big hesitation that whether you would be able to do that.
Yes.
Many people had that same feeling, said there's nothing wrong with that. But I guess my big question is really, if you find yourself back in that jury room and you felt that the evidence supported the death penalty in this case, looking into yourself, would you be able to raise your hand and vote that the death penalty should be imposed on other people?
It would be really hard for me, but I think it really, like, I don't know, it really depends on, like, the actual, like, the moment. I don't know, it's really hard because the death penalty is really serious, and me being put in that position, I'm not sure if I could. It all depends on what
Fair
I
enough.
hear.
So basically, you have a reasonable doubt, if put in that position in your mind, whether you would be able to do this.
Yes.
Fair enough. Thank you, sir. I appreciate your time. No further questions, Your Honor.
No, you wish to inquire?
Hello.
Hello.
It's supposed to be really hard.
Yeah.
I know, I mean, it's not fun to sign people up to be
Yeah.
jurors in this case, but it's supposed to be really hard deciding whether somebody lives or dies, right?
Yes.
And because of that, and because death is never required, not in any case, not in this case, not in the worst conceivable case you can imagine, what the law requires for someone to be able to serve as a juror in a case where the death penalty is a possibility is for that juror to be able to give meaningful consideration to both penalties, the life penalty and the death penalty. Can you give meaningful consideration to both possible penalties?
Yes.
Okay. If you were on an island and you were the king of that island and you made up all of the rules, would your island have the death penalty?
I don't think so, no.
Okay. But recognizing that we're in Florida, you can still follow the law here.
Yes.
Okay. And we've already talked about this quite a bit. You understand death is never required.
Yes.
And if one juror decides that the verdict should be life, then the verdict will be life. Follow me?
Yes.
Where does the decision to give life come from? We call it mitigation. It's why any one juror would choose life or not choose death. With me?
Yes.
Doesn't have to be unanimous. Each juror could find something mitigating to himself or herself. And it could be even something seemingly small, like a smile observed between the defendant and a family member, and that juror sees that and says, that's enough for me, I'm giving a life penalty, I found that mitigating.
Yes.
And these things can get kind of contentious occasionally. Not always, right? Because 12 people might have differences of opinion, and they might have strong opinions, right?
Yes.
And the law encourages jurors to deliberate, to carefully consider. But what the law also requires is that for a just verdict to be returned, all 12 jurors' individual moral assessments have to be reflected on the verdict form. Follow me?
Yes.
It would be a miscarriage of justice if not all 12 people's individual moral assessments about whether Mr. Loyd lives or dies are reflected on that verdict form. With me?
Yes.
And so if you've reached a verdict for life and you feel like it's not being respected, you can say, hey, we're done here. Let's get the deputy to get the judge. We're done. I've reached a verdict for life, and we're done. Can you do that?
Yes.
I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further.
All right, anybody have a motion? I do, Your Honor. All right, run up to the bench. Just a second, sir, we'll be right with you. All right, sir, we appreciate your time and your attention. I'm going to excuse you from this case as a juror. You're free to go. Thank
Thank
you.
you. Wait, so does that mean?
You don't have to come back. You're
Oh,
done.
Okay, thank you.
You're very welcome. Thank you. All right, juror in seat number 16. right, good afternoon, ma'am. How are you this afternoon?
Good, thank you.
All right, we have a few more questions for you. As I indicated, I'm going to start, and then the attorneys are going to ask you some questions once I'm done. There aren't any right or wrong answers to these questions. We need to know whether you can do your job as a juror in this case, so it's very important that you answer the questions fully and honestly. Just tell us what you actually believe, all right? Let me start with asking you, confirming you have never seen anything about this case or heard anything about it prior to coming in here?
No,
All right. Do you have any personal, religious, or moral objections to the death penalty?
I don't know how I feel about the death penalty. There's no religious reason for it, but I'm not sure about it.
Okay. So to sit as a juror in a case like this, the law never requires you to impose death. Let me just start by that. The automatic sentence for first-degree murder in the state of Florida is life without parole. But in certain cases, when aggravators are proved, at least one aggravator is proven by the state beyond a reasonable doubt, then death becomes a possible sentence. Jurors have to be able to fairly consider both death and life as a possible sentence in order to do their job as jurors, all right? No one's telling you have to vote for death, but you have to be able to fairly consider it. And if, after weighing everything, you determined that death was the appropriate sentence, can you vote for it?
I can't answer that.
Okay. Do you have a doubt as to whether you could do it?
I don't know how I feel about the death penalty. So you're asking me something I'm not sure of.
Okay. Unfortunately, ma'am, I need definitive answers today.
I don't know. I mean, that's the only thing I can tell you.
You can't tell me that you would be able to impose death today.
No.
You're not sure?
I'm not sure.
Okay. State?
State moves, Your Honor.
Any objection? You can ask her a few questions. Hold on,
Yeah, I can't hear you.
briefly.
Good afternoon. We all appreciate that you probably aren't sitting at home talking about the death penalty or thinking about the death penalty. Fair?
Right.
But this is our only opportunity to ask you these questions. And I don't know is a fair answer, but we're going to ask that you try to give as definitive of answers as possible. In order to serve on a capital jury, a juror has to be able to give meaningful consideration to both possible penalties for first-degree murder: life in prison without the possibility of parole and the death penalty. So the question is, can you give meaningful consideration to both possible penalties?
I certainly would consider it.
Okay. Tell me what your hesitation is.
I don't know if I believe in the death penalty.
Okay. But you've indicated you could consider it.
I mean, I definitely would consider it, but I don't know if that's the right thing to do, to kill someone.
Sure. And no one can tell you that answer. Right? And I will tell you, though, that death is never required, not in any case, not in the worst conceivable case you can imagine. What the law requires is if a defendant is found guilty of the premeditated intentional killing of an innocent victim, right? So the state has to first prove this defendant guilty beyond a reasonable doubt of the crime of first-degree murder. With me?
Yes.
Then the state has, so then if that happens, then we go to the second part of the trial, the sentencing part. And the only possible penalties for first-degree murder are life or death. Still with me?
Yes.
The state has to prove the existence of one aggravating factor. You okay?
This mask is driving me crazy.
I feel you. State has to prove the existence of one aggravating factor beyond a reasonable doubt, at least one. Still with me?
Yes.
The state has to prove that then as a jury you would find if that aggravator is sufficient or not to warrant the death penalty. You would then decide if the aggravation outweighs the mitigation. And even then, the last question is death the appropriate penalty in this case? And even if you're like, yes, 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 you can still say, I'm just not voting for the death penalty in this case. So the question is really, can you listen with an open mind, hear the facts, and follow that law, giving truly meaningful consideration to both possible penalties?
I have to do what I feel is the right thing.
Okay. Separate question. I'm not just...
And I'm not, weighing whether this person killed another person or not. I'm just saying that I have to decide for myself whether I would be willing to say, yes, this man needs to die.
Okay. May I have just a moment, Your Honor?
All right. Either side have a motion?
Yes, Your Honor.
You objecting? You want argument or you just object? Okay. All right. Ma'am, I appreciate your willingness to serve and your being here today, but I'm going to excuse you from this case. I don't think this is the case for you. All right.
It's something I've never done in my life.
And believe me, I completely understand.
I've served on juries before. It's just,
I
this
know.
is like,
This is a whole nother level, ma'am.
absolutely, I'm sorry.
No, you don't need to apologize. You were honest, which is exactly what I asked you to do.
Okay.
You have a good afternoon.
You too, thank you.
Thank you.
I'm sorry.
All right, juror in seat number 28. I'm skipping 7 and 24 because they're in the next group. They weren't instructed to begin with.
Yes, please. Yes, sir.
Good afternoon, sir. How are you?
Good afternoon, doing well.
Sorry about the wait, but as you can understand, this is a pretty serious case, so we need to take our time, all right?
Understood.
Let me confirm that you know nothing about this case. You've never heard about it before today?
That is correct.
Okay. Do you have any, I'm sorry. I'm going to ask you some questions, and the attorneys are going to ask you questions. There aren't any right or wrong answers to these questions. We need to know whether you could do your job as a juror if selected, so it's very important that you just answer the questions fully and honestly. If you don't know, just say you don't know, okay?
Understood.
Do you have any moral, religious, or personal objections to the death penalty?
I do not.
All right. Are you someone who believes that if someone is convicted of first-degree murder, premeditated murder, the intentional killing of another human being without any legal justification for it, are you someone who believes that that person should automatically be sentenced to death?
No.
All right. Florida has no automatic death sentence, all right? And are there any types of cases where you personally would be unable to consider life and you would automatically sentence someone to death if they were convicted of first-degree murder?
None that I can think of.
All right. This case involves the death of a police officer. Would you automatically sentence someone to death? I mean, you haven't heard anything about the case, all right? My question is this. Without hearing anything, without, hearing aggravators or mitigators or anything, are you someone who would say, you kill a police officer, I convict you of it, first-degree murder, I'm sentencing you to death?
No, not automatic.
All right. You also heard me tell you that Mr. Loyd was convicted of the murder of Sade Dixon and her unborn child and sentenced to life without parole.
I did.
All right. That can't be used to decide whether or not he's guilty of this case. All
That
right?
is understood.
But my question becomes this. Are you someone who, without hearing anything else, not having heard any aggravators, mitigators, nothing, would be saying, look, if you've killed someone before, I'm going to sentence you to death if I convict you of killing someone else.
No, Your Honor.
All right. You heard me explain about how you proceed in these cases once there's a penalty phase, all right? So to get to a penalty phase, there has to be a conviction for first-degree murder, the intentional killing of another person without any legal justification. You with me so far?
I am.
Yeah, you can't get to penalty phase until you've done that. All right. So at the penalty phase, the state has to put on evidence of an aggravator or aggravators. This jury has to find at least one exist beyond a reasonable doubt, that the evidence proves that one, at least one, beyond a reasonable doubt, before you can even think about imposing a death sentence. You understand that? All right.
I do.
The defense is going to put on their mitigation, the reasons they believe your vote should be life without the possibility of parole. I'm going to give you the jury instructions that explains all this to you and tells you that you have to go back there and weigh these. And by weighing them, we mean you all can talk about it amongst yourself. That's up to you. If you want to talk about it, you can. Most jurors do, but it's up to you. We don't direct what you all do. You have to then weigh them. And by weighing, what we mean is you individually have to decide which ones you believe to be important to your decision. And you can believe them, disbelieve them. You could say, I don't believe this aggravator exists, or I don't believe this mitigator exists. Or you can say, I find this mitigator to be really important to my decision. I find this aggravator to be really important. You weigh all that out. You've got all the evidence, you've heard all the testimony. So at the end of that, if all of that process led you to believe that life without parole was the appropriate sentence, could you vote for that?
Absolutely.
And if it led you to believe that death was the appropriate sentence, could you vote for that?
I could.
Do you have any doubts about your ability to go through that process?
I do not.
All right. Last questions I have for you. The insanity defense. I told you Mr. Loyd has raised it. This is in the guilt portion of the case where you're trying to determine whether or not he's guilty. The burden, this is the only time the defense has a burden, okay? The defense has to prove it by clear and convincing evidence. The state doesn't have to prove it. So you've gotten to the end of the case and you think at the end, you've got all the evidence. I think they proved it. I think he was insane at the time. Could you reach a verdict of not guilty by reason of insanity?
I could.
All right, thank you, sir. I don't have any other questions. The attorneys are going to ask you. Mr. Buxman, you may inquire.
Thank you, Robert. Good afternoon, sir.
Good afternoon.
I noticed on your jury questionnaire that you indicated you had a friend or family member or were related to law enforcement in some way.
That is correct.
And what relationship is that law enforcement officer to you?
He's my brother-in-law.
Okay. Is he still active?
He's retired now.
Okay. And which agency did he work for?
Rochester, New York Police Department.
For how long?
Over 20 years.
Okay. Knowing that this case involves the murder of a law enforcement officer, would you still be able to listen to all the evidence and render a verdict in this case based solely on what you hear in the courtroom and not let whatever feelings you may have an affinity, obviously, to your brother-in-law being in law enforcement?
I could.
Okay. And what, I noticed in your questionnaire, you do current occupation, AV procurement and facilities. What does that mean? What do you do?
I'm in charge of my companies, everything that is in procurement, which is anything you buy, lease, or contract for, and then all the real estate, corporate real estate.
Okay. How long have you been doing that?
This job is about a little bit of 5 years now.
Just a few follow-up questions on your feelings about the death penalty. Based on your answer, I gather you're kind of down the middle of the road. In some cases, you feel the death penalty may be appropriate. In some cases, it may not, right?
Correct.
Okay. And the bottom line question is, are you able to listen to all the evidence, both the aggravating factors and the mitigating circumstances, truly consider it, weigh the evidence on each of those to determine if it's been proven and what importance you give before you render an ultimate decision?
Yes, I am capable of that.
You keep an open mind, listen to everything, and then make a decision as far as the proper punishment in this case, if we get to that point.
I can.
Thank you, sir. No other questions, Your Honor.
Thank you, Mr. Buxman. Ms. Miller, you may inquire.
just have some follow-up questions. First-degree murder in Florida is defined as the intentional, premeditated killing of an innocent victim. That defendant thought about it, meant to do it, and did it. And if you find somebody, or a jury finds somebody guilty of first-degree murder, that jury would have considered any available defenses to that defendant, something like self-defense, right? But any of them. And in finding that defendant guilty of the intentional, premeditated killing of an innocent victim, that jury would have rejected any of those defenses. With me?
Understood.
So the question is, once you've decided someone is guilty of that crime without legal justification, excuse, or defense, is death the automatic penalty that should be imposed?
No, it's not the automatic.
Why not?
Because there's going to be a lot of, would appear, a lot of guidance given to me on, when that is appropriate. And I have to take that in context of that guidance, right? And, based upon the mitigators and the aggravators, I have to figure out what is the appropriate punishment from that. And
Sure.
That's how I think I would approach it.
Sure, and let me clarify something. All of those instructions that the judge talked about, that's if you're selected to be a juror in this case, right? The oath that you're taking right now as a prospective juror is to tell the truth. And so I have no doubt that you are someone who can follow the law. What I'm looking for is your feelings, right? Some people say, I hear that law. That's great. Some people say, I hear that law, but I, for me, know that if somebody is guilty of the intentional, premeditated killing of an innocent victim, death is really the automatic penalty.
Understood. I think my feelings are irrelevant. I think it's about the law and about, the case that you and they put forth. It's not about what I'm feeling.
But I'm asking you what you're feeling.
Well, a feeling about what?
What are your feelings about the death penalty?
It's appropriate in some cases.
Okay, what cases?
Objection, Your Honor.
Sustained.
Okay, let's do a different question. If you are on an island and you're the king of that island, you get to make up all the rules. You're in charge.
Right?
Would your island have a death penalty?
Yes.
For who?
Objection calls for
Sustained.
In what circumstances?
objection.
Sustained.
Have you ever read in the newspaper or seen a movie or a TV show about somebody getting the death penalty and thought that was an appropriate penalty in that circumstance?
I can't think of any particular case, but I would say it's probable, yes.
It's a what, I'm sorry?
Probable?
Probable, okay. And can you recall any specific set of
I
circumstances?
really can't, no, I'm sorry.
The judge asked you before, too, about law enforcement, right?
Correct.
And you have a family member who's a law enforcement officer.
Correct.
And so again, some people, because of their background, are more sensitive to the fact, understandably so, that a law enforcement officer lost her life in this case.
Mm-hmm.
So once you find the defendant guilty of the premeditated intentional killing of a law enforcement officer, what are your feelings about death being the automatic penalty then?
No, I understand your line of question, and I have high regard for the police officers in military and anybody in public service. But just because of their designation, I was military as well, doesn't mean that there should be a certain, verdict rendered.
Okay. And that's where this is the only opportunity you and I have to speak.
Yes, understood.
Right? We may not even get to the second part of this trial, the penalty phase. That only happens if the state's proven Mr. Loyd guilty or if we fail to prove that he's not guilty by reason of insanity. With me?
I'm with you.
But the law requires that we have this conversation now. And so, again, only you know what's inside you. And I understand that you're like, I'm trying to put my feelings aside and just talk about the law. But I really want to know what your feelings are about death as a starting place for somebody who kills a law enforcement officer in an intentional way.
Objection asked and answered, Your Honor.
Sustained.
When we talk about mitigation, before I get there, I'm sorry. Scratch that. You've also heard that Mr. Loyd has been previously convicted of another murder and is serving life without the possibility of parole for that crime.
I have heard that.
And so the question is, for this murder here, if you know someone is already serving life for murder, is death the automatic penalty?
Objection calls for pre-commitment.
Sustain. And I believe I asked him this question.
I'm sorry, I didn't hear you.
I think I asked him this question.
And that's why I just didn't hear his answer. I was just, so the state's objection was pre-commitment, so.
I asked him the question. Sir, do you remember when I asked you this question?
I heard your questions, Your Honor.
All right. Can you repeat your answer to that question?
Could you repeat the question and I'll answer it?
The question I asked you is, before anything got started in this case, I've already told you that he was convicted of the prior murder,
Yes, Your Honor.
right? You haven't heard anything, you haven't heard any testimony, would you?
That you could give truly meaningful consideration to, and that it could potentially impact you.
Yes, I could.
You would probably agree with me that 12 people don't all feel the same way about all of these things. Fair?
That is fair.
And the law contemplates that. The law contemplates that people reach 12 individual moral assessments about whether Mr. Loyd lives or dies. Otherwise, it's not a just verdict. With me?
I'm with you.
And so if somebody reaches a verdict and is bullied or badgered into changing his or her individual moral assessment, that would be a miscarriage of justice. With me?
With you.
And so you're not, if you're back in the jury deliberation room, going to bully or badger anybody to change their mind just to agree with you.
Of course not.
And you would step in and not allow anybody else.
I would.
May I have just a moment, Your Honor?
Yes, ma'am.
I know. No.
All right, let me see the attorneys at the bench. All right, sir, we're going to bring you back for one last round of questioning. We will be picking the jury that day. I don't know what day that is because I have to have a certain number of jurors coming back for me to be able to do that. So I'm going to change your color to purple. We're going to give you a purple dot. So now when you call the jury room for the date to come back, you're listening for purple. All right?
Understood.
You're eventually going to hear purple dots return on such and such a date. Don't even bother to call before Wednesday at 5, because I assure you it would be a miracle if we came back Thursday. But start Wednesday at 5 and check. It'll probably be next week that we bring you back.
Okay.
Because we're picking the jury that day, we're sequestering the jury that day. So when you come back, you need to have a suitcase packed and ready to go. In that packet that we just gave you are several things. One is the phone number to call, slip of paper with the phone number to call to find out when you're supposed to return. There's a letter for your employer, and there's a sequestration package that explains sequestration to you in more detail, and it gives you a list of suggested things to pack. Leave your suitcase in your car. If you're not chosen for the jury, you won't need it. If you are, we'll make arrangements for you to pick it up. Do you have any questions?
No, at this time, Your Honor.
All right, thank you so much. You have a good afternoon.
You do the same.
Okay, let's bring the juror in seat number 30, juror number 55 in. Good afternoon, sir. How are you?
Good, and yourself?
I'm well, thank you. All right, I'm sorry that we've kept you waiting, but this case is really serious, so we're having to take our time, as I'm sure you understand.
Yes.
I just want to verify that you did not indicate, you've never heard anything about this case, is that correct?
No, I
Before you
haven't.
came here? Okay. All right. So we're going to have a few questions for you. I'm going to start, and then the lawyers will have their chance to ask you some questions. There aren't any right or wrong answers to this. It's really important that we be able to determine whether or not you can do your job as a juror in this type of case. So all we really want you to do is answer the questions fully and honestly. Just tell us what you believe. That's what we're trying to find out, all right? To make sure that if you ended up on the jury, you could do your job. Well, let me start by asking you, do you have any moral, religious, or personal objections to the death penalty?
No, I don't.
All right. Are you someone who believes that if a person is convicted of first-degree murder, the intentional killing of another person without a legal justification for it, you have no defense, you intentionally killed someone, do you believe that that person should automatically be sentenced to death?
No, I don't.
All right. Well, that is Florida law, as I explained it to you. So let me ask you a couple more questions about that. In this case, the first count, first-degree murder, involves the death of a police officer. So if you found beyond a reasonable doubt that Mr. Loyd was guilty of first-degree murder of a police officer, would you automatically vote for death?
No, I would not.
All right. You heard me describe what the process is for how you do this. If there's a conviction on first-degree murder, and it has to be beyond a reasonable doubt, you're now in the penalty phase. The state has to prove at least one aggravating factor. Aggravating factors are statutory, and they're the reasons that a case, because in Florida, the automatic sentence for first-degree murder is life without parole. Only if the state can prove one or more aggravators can death become a possibility. So they have to prove the aggravating factor or factors beyond a reasonable doubt. If a jury finds one or more of those, then you can consider death. The defense has mitigation. They're the reasons that they believe your vote should be life without the possibility of parole. You have to be able to listen to both sides with an open mind, not with a closed mind, not, yeah, I'll listen to you, but this is how I'm going to vote. You have to be able to listen to both sides with an open mind. I will give you the jury instructions at the end of all of that evidence. You can go back in the jury room with your fellow jurors. You can discuss it as much or as little as you like. But in the end, you have to make a personal decision. You're going to be asked to weigh the aggravators and mitigators. And what we mean by that is you need to determine how important things are to you making your decision. All right? So you can find that an aggravator is very important to you or it's not important to you at all. Same thing with the mitigation. You can find this is very important to my making a decision. This one I just don't find that important. You can just not believe them. Say, I don't find this aggravator or this mitigator. It's totally up to you. Then you all have to vote. It takes 12 of you. It's a unanimous vote in order for a court to be able to impose death. But if you went through that whole process, you've weighed the aggravators, you've weighed the mitigators, you've listened to all the testimony and the evidence in guilt and penalty, and now you've made the decision that you believe life is the appropriate sentence without parole. Could you vote for that?
Yes, I can.
If you believe the appropriate sentence was death, could you vote for that?
Yes, I would.
All right. And you understand that death is never required, but you don't have to vote for death. You understand that?
I do understand it.
All right. I told you that Mr. Loyd was convicted of the murder of Sade Dixon and her unborn child and sentenced to life without parole. And I told you can't use that to decide whether he's guilty of these charges. You understand that?
Yes, I did.
Do you have any trouble following that direction?
No trouble at all.
Right. Is there anything about that fact that before you ever heard anything else in the trial, you haven't heard a word, that you would be thinking, if this guy gets convicted of first-degree murder, I'm sentencing to death because of that prior murder?
No, I would not.
All right. And then my last question to you is the insanity defense. Mr. Loyd is raised that. This is in the guilt phase when you're trying to decide whether he's guilty or not. The defense has to prove that. It's the only time they have to prove something in the guilt phase, and it's by clear and convincing evidence. If at the end of all the evidence in the guilt phase, you believe they've proven it and you believe he was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
Yes, I would.
All right, thank you, sir. I don't have any other questions for you. The state's going to ask you some questions, then the defense. Mr. Buxman?
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
I saw in your jury questionnaire that you have been a juror before.
Excuse me?
Were you a juror before at some other case?
I was just selected to do one, and that was when I lived in New Jersey.
Okay. Did you actually deliberate?
No, I was not.
Okay, you didn't make it this far.
Right.
I understand. The judge gave a thorough explanation of the death penalty process, so I'm not going to go reiterate all those points again. Just have a few point questions. From your answers, it seems like you are kind of middle of the ground as far as death penalty. In some cases, it's appropriate. In some cases, it may not be, right?
Yeah, I would say, according to evidence.
Okay. But do you feel that based on the evidence, in some situations it could be appropriate, in some cases it may not be appropriate?
Yes, yes.
The real crux of this questioning is, are you able to listen to all the evidence with an open mind, truly consider all the information given to you, and only after you consider that, then make a decision, if we get to that point in the trial where the penalty phase becomes an issue, of what the proper punishment should be?
Yes, yes, I can.
And in keeping that open mind, would you be able to do that even if at first blush something may sound not really mitigating or not really important, but until you get all the details and all the evidence surrounding that, could you hold off your judgment until you get all that additional evidence?
Yes, I can.
Okay. Would you be able to consider any and all mitigation presented to you?
I can consider it, yes.
So if I stood off here and went through 100 different potential pieces of mitigating evidence, would your answer always be, yes, I would consider it, I would listen to the evidence, and then only then make a decision?
Well, I would hear both sides before I made my final decision.
Would you ever, hearing a piece of mitigating evidence, say, I'm not listening to any more, I don't think that's valid, I don't like it? Or would you keep an open mind and listen to the evidence as it relates to that mitigating circumstance before making a decision?
Yes, I would listen and then make a decision after I've listened.
Okay. The judge brought up the insanity issue, and I just have a couple personal questions, a little bit more personal, about mental health issues. Do you have any experience, either yourself, a close friend, or a family member with mental illness of any kind?
No, I don't.
Okay. Some people in our society think mental illness, that's not real. That's just, people making things up to get away with things or something like that. I'm assuming you're not one of those people, are you?
No, not at all.
Do you believe mental health issues are real in society?
Yes, I do.
Okay. Thank you, sir. No further questions, Your Honor.
Thank you.
Mr. Buxman. Ms. Miller, you may inquire.
Hello.
Hello.
Mr. Buxman asked you, from your answers, it seems like you were kind of middle of the ground as far as death penalty. In some cases, it's appropriate, some cases, it may not be right. Your answer was, yeah, I would say according to the evidence.
Yes.
What does that mean?
It means that I would listen to both sides, see evidence, and put it in my mind, and not put all my personal feelings on the side, and just go with what exactly was shown or said.
Okay. And this is tough because in deciding whether somebody lives or dies, it is your individual moral assessment. And that's why it is totally appropriate for you to talk about your feelings in this setting. That's why we're here. Okay? And so when people say evidence, I just want to make sure we're on the same page. In order to even get this part, the second part of the trial, where you're considering whether the penalties are life or death, the defendant has to first be found guilty beyond a reasonable doubt of the intentional premeditated killing of an innocent victim. The defendant thought about it, meant to do it, and did it. With me?
Yes.
And if a jury found that defendant guilty of first-degree premeditated intentional murder, that jury would have considered any available defense to that defendant, like self-defense, for example. And in convicting him of first-degree murder, that jury would have rejected any of those defenses. And so the question becomes, for somebody who's committed intentional premeditated murder of an innocent victim without any legal excuse, justification, or defense, is the death penalty the automatic penalty once that decision's made?
It shouldn't be the first thing automatically.
Why not?
I feel that there could be a lot of other evidence that can be determined that this person did not do it maliciously or did not do it intentionally because of their mental illness.
Okay. Let me just clear up one thing. I hear you. In the second part of the trial, you may hear evidence, well, in both parts of the trial, actually, you may hear evidence about mental health or mental illness. But if you get to the second part of the trial, you as a juror would have determined that the defendant was not guilty by reason of insanity. Do you see what I'm saying? Yes. So not guilty by reason of insanity is a defense to the crime. So the first part of the trial, the state has to prove that Mr. Loyd is guilty of the crime of first-degree murder beyond a reasonable doubt. And then the defense has to prove that he's not guilty by reason of insanity. And if you reject that defense, that's how you get to the second part. You with me?
Yes.
So knowing if you're in the second part of the trial, you've rejected insanity as a defense. Is death the automatic penalty then?
No.
Why not?
I feel that life in jail would probably be more service to that person for what they did.
To the defendant, you mean, when you say that person?
Yes.
Okay. Do more service? Is that what you said? I apologize.
Well, paying for what they did in jail.
Okay. Do you think life in prison is a more harsh penalty than the death penalty? Is that what you're saying?
Yes.
Why is that?
They're living their life, the rest of the life, where not just ending it and forgetting it.
Okay. Do you think that you would always vote for life in prison because it's, in your opinion, the worst of the two penalties?
No.
Okay. Knowing that the victim, the intentional premeditated killing without legal justification, excuse, or defense is of a law enforcement officer, does that change your answers to any of these questions?
No.
So death doesn't become the automatic penalty?
No.
What if the purpose in killing that law enforcement officer was to eliminate that person as a witness?
Objection, Your Honor.
Can we approach? Let me ask you about the nature of the crime. If you heard that it was committed in an especially heinous, atrocious, and cruel manner, would death become the automatic penalty?
Objection. Same grounds.
May we approach? These are category-specific aggravators.
Let me see the attorneys at the bench.
Let's talk about this. Oh, I'm sorry. Let's talk about mitigation. Mitigation is simply a legal term, which means why anyone to choose life or not choose death. Okay? And when we talk about being able to give something meaningful consideration, right? the possibility that hearing something might affect your penalty, the penalty verdict you think is appropriate. You know what I mean?
Yes.
And so the question is, do you think that hearing about a defendant experiencing the effects of racism would be something that you would be able to give meaningful consideration to?
No.
Why not?
I don't think that racism should be part of what you've done wrong by either taking somebody's life or doing the wrong thing.
Okay. How about the defendant having a tough childhood, coming from a rough background? Is that something you would be able to give meaningful consideration to?
No. There's certainly a lot of places that people can get help, whether it be social media friends or even other places that are in their realm of being able to get it.
Understood. And so you can appreciate that 12 people might have differences of opinions on these kind of things, whether somebody lives or dies.
Yes.
And the law contemplates that and says that's A-okay.
Yes.
And so the question becomes, if you're in the deliberation room and somebody disagrees with you, you're not going to bully or badger that person to change his or her opinion just to agree with you, right?
No, I will not change, make somebody change their mind over my opinion, but certainly there could be time to speak about it and have differences of opinion and to why, and maybe come to an agreement where all of us can agree.
Sure. I totally hear you. And the law encourages folks to deliberate, which means to carefully consider. And some people have no problem articulating why they feel a certain way. And some people say, I don't know, and I'm not able to articulate it. I just know for me the penalty is going to be life in prison. And that's okay too. With me?
Yes.
And so the law, in contemplating all that, says that in order for a just verdict to be returned, all 12 people's individual moral assessments have to be reflected in the verdict. Right? So there's nothing that requires all 12 people to agree in the second part of this trial when you're deciding life or death.
Yes.
Right? So you can talk about it, but if somebody says, I've reached a verdict for life and we're done here, that's okay too.
Well, we would have to speak about it if it's just one person, so that we all can agree on it. So we probably have to take some time and speak about it amongst each other out loud, not just mentally and say, I don't know, and have your reasoning as to yes, no, or why, or indifferent.
I see the confusion. 12 people don't have to agree. The only time they have to agree in penalty is in order for a death verdict to be returned. If one person says that life should be the verdict, then life will be the verdict. So all 12 people don't have to agree on a verdict of life. The only way a death verdict is returned is if all 12 people agree. Does that make sense?
Yes.
And that's my point, is that if somebody says, I've reached a verdict for life, and I really can't express it anything more than to say, I just know for me, I'm not imposing a death verdict in this case, that's okay. You don't have to agree.
It is okay, yes.
Does that make sense?
Yes, it does.
All right. May I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further. I do have a motion.
All right. Let me see the attorneys at the bench. All right, sir. We appreciate your time and attention for this case. I'm going to excuse you as a juror in this case. You are free to go.
Thank you.
Thank you. 38, please. Good afternoon. How are you, ma'am? I said, good afternoon. How are you doing?
Good.
Give me 1 second. All right, ma'am. Welcome back.
Thank you.
I'm sorry we kept you waiting. It's a really serious case. We need to take our time and do a good job. So we're going to be asking you some questions this afternoon. The questions are meant to find out whether or not you can do your job as a juror. That's why we're asking you these questions. There aren't any right or wrong answers to them. There's just what you believe, what you think. What we want you to do is be open and honest with us and answer the questions fully, all right?
Okay.
Let me start with, you've never heard anything about this case prior to coming here? Is that correct?
No.
All right. Do you have any personal, religious, or moral objections to the death penalty?
Nope.
No? Okay. Are you someone who believes that if a person is convicted of first-degree murder, the intentionally killing another person with no legal justification for doing it? No, it's not self-defense, it's just they intentionally killed someone. If you convict someone of that, are you someone who thinks that that person should automatically be sentenced to death?
I need to have like the information, the truth and evidence
Okay?
to make that choice.
All right. So let me go over this with you carefully to make sure you understand how this works. In these cases, there's the first phase, the guilt phase, all right? So both sides are going to present evidence. The state has to prove beyond a reasonable doubt, that's the standard, that Mr. Loyd is guilty of first-degree murder, intentionally killing another person with no legal reason for it. So you have to be convinced of that. You have to be convinced of it beyond a reasonable doubt before you could ever convict him of that. And it's only if he's convicted of first-degree murder that the penalty phase, the decision between life and death, becomes the next decision the jury has to make.
Correct.
Follow me so far?
Correct.
All right, so if you had made that decision in this case, would you be able to consider both life and death as possible sentences, or would you automatically vote for death?
I think both.
Okay?
Yes.
And in the first count, the death is of a law enforcement officer, a police officer. Is there anything about that that would cause you to automatically vote for death if he was convicted? Like, in other words, right now, you're sitting here thinking, if I convict him of this, I'm voting for death. I don't care what the evidence is.
No, I need to have the
You need
information.
to listen to the evidence.
Yes.
Okay, that's what you're supposed to do, all right?
Yes.
So let me ask you one more question about this. You remember I told you that he's been convicted of murdering Miss Dixon and her unborn child, and he was sentenced to life in prison without the possibility of parole. You remember that? Okay. You
Yes.
can't use that to decide whether or not he's guilty of these charges. But sitting here right now, having heard nothing, would you be someone who was thinking, well, if I convict him of murder in this case, and he's already been convicted of murder in another case, I'm voting for death? Or would you be wanting to listen to the evidence?
I need to listen.
Okay. And do you understand the evidence I'm talking about is not the evidence about whether he's guilty or not, but the second part, the penalty phase, the aggravators and the mitigators. You understand that? All right. The aggravators are the reasons the state is asking that death is even a possibility in this case. The state has to prove at least one aggravator beyond a reasonable doubt before you can even consider voting for death. The defense has what's called mitigation, reasons they believe that you should vote for life without the possibility of parole. Do you understand that?
Yes.
If at any point I lose you, let me know.
No.
So at the end of the penalty phase, you've already made the decision to convict of first-degree murder. Now you're deciding death or life. So then you're going to go back in that jury room with the instructions from me on how to do this. But in essence, what you're doing is, first you're determining, was any aggravator proven beyond a reasonable doubt? If the answer is yes, Then you go on. Now you're going to weigh aggravators and mitigators. And by weighing them, what we mean is you have to decide which ones are important to you in making your decision. You can not believe it, any of them. You can decide, I'm not believing this mitigator or this aggravator. You can decide, I think this mitigator is the most important thing I heard today, and that's what I want to base my decision on. Or you can decide these aggravators or this aggravator, that's the most important thing I heard today. You weigh it all out, and you can use all the evidence and everything you've heard, and then you have to decide life without parole or death. So if after you did all of that, you thought that the sentence should be life without parole, could you vote for that?
Yes.
And if you thought the sentence should be death, could you vote for that?
Yes.
Okay. So my last question for you is this. Mr. Loyd's raised the insanity defense, all right? That's in the guilt phase, the first part of the trial, where you're trying to decide whether he's guilty or not. It's the defense that has to prove insanity, not the state. The defense has to prove it by clear and convincing evidence. But if at the end of the guilt phase, when you're trying to decide whether he's guilty or not, you were convinced he was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
I'm not sure about that one,
Okay. What is it that's causing you to hesitate?
because they already convinced to be guilty.
No. This is you haven't decided whether he's guilty or not. All
Okay.
right. What you're trying to decide whether he is or he isn't. Not guilty by reason of insanity is a defense
Okay.
to the charge of murder. This defense has to prove it. Remember, I told you, insane. Has a mental illness or a defect that affects the ability to understand what you're doing and its consequences, or even if you understand what you're doing and the consequences, you don't realize it's wrong. That's sort of the definition of it. But assume for purposes of my question that that's been proven. The defense put on evidence and you believe it. You believe he was insane at the time. Could you find him not guilty by reason of insanity?
At the time that they have the evidence that he is insanity, but he made the decision. Well, he made the charge. He killed the person, so he's going to be guilty.
All right, so you couldn't accept that he was, that's not evidence that you can listen to. correct?
Exactly.
All right, State,
We moved on.
any objections? All right, thank you, ma'am. This isn't the case for you, but we appreciate your willingness to serve and being here today. Have a great day.
Thank you.
Excuse me. What juror was that? 42? No. She's seat 38? Okay. So I have 42 left. All right. Juror in seat number 42. Stace, 39 got excused for cause, right? Okay. And this would be the last one from 9 o'clock. The next group is the 2 o'clock? All right, great. All right. This is the last one from 9 o'clock. There's two, again, 7 and 24 were late, so they're in the 2 o'clock group. And the 2 o'clock group includes panel 5 and 6. All right, how are you this afternoon?
I'm well, thank you.
All right. I apologize for the delay.
okay.
It's a serious case. We have to take our time doing this. So we just have a few questions for you this afternoon. There aren't any right or wrong answers to this. We need to determine whether or not you can do your job as a juror in this type of case. That's the point of these questions. So it's very important that you just answer the question very honestly and as fully as you can. Don't worry about what your answer is. We're not looking for a particular answer. So let me just confirm that you don't know anything about this case, correct? Except what I told you.
Correct.
All right. Do you have any moral, religious, or personal objections to the death penalty?
Yes.
All right. And which one is it?
No.
All right. How long have you held that conviction?
Always.
Always? So is that conviction so strong that regardless of what the evidence or the law was, you could never vote for the death penalty in a case?
I couldn't see what would allow me to. I don't foresee anything that could.
That could get you to vote for a death penalty?
Yeah.
All right. You have to have an open mind as to both death and life. I assume you would have no trouble voting life without the possibility of parole, correct?
No.
So if you were asked to listen, if you had convicted someone of first-degree murder, now you're asked to listen to the state present aggravators, reasons as to why death should be the sentence. You're never required to vote for death, okay? But you have to be able to consider it with an open mind. If, after considering everything, you thought death is the appropriate sentence, would you be able to vote for it, or would you automatically vote for life?
I would automatically vote for life.
All right, thank you, ma'am. State?
No questions.
Defense? All right, Ms. Miller wants to ask you some questions.
Hello.
Hi.
The law allows somebody with conscientious objection or religious scruples to the death penalty to serve on a capital case if that juror is able to give meaningful consideration to both possible penalties, the life penalty or life without the possibility of parole, and the death penalty. Could you give consideration to both possible penalties?
Yes.
Okay. And so what is required of you in the second part of this trial, right? So the first part of the trial is, did the state prove this defendant guilty beyond a reasonable doubt? And in this case, Mr. Loyd's case, Mr. Loyd is pled not guilty by reason of insanity, right? So the only way we even get to the second part of this trial is if the state proves Mr. Loyd guilty beyond a reasonable doubt of capital first-degree murder, and if we fail to prove he's not guilty by reason of insanity. With me?
Mm-hmm. Yes, I am.
And so we may not even get here, but this is the only opportunity that we have to talk about possible sentence. So the law requires that we talk about it, even though we may never even get to the second part of this trial. Make sense?
I understand.
And so if you're in this second part of the trial, what you would have to decide as a juror is if the state proved the existence of at least one aggravating factor beyond a reasonable doubt, if that aggravator is sufficient to warrant the death penalty, if the aggravation outweighs the mitigation, and then the last question is death the appropriate penalty? And even if you say yes, 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 you are still never required to vote for death under any circumstance, not in the worst conceivable case you can imagine. So even if the state has proven the existence of an aggravator, it's definitely sufficient to warrant death, it outweighs the mitigation, you still don't have to vote for the death penalty. With me?
All right.
Could you follow that law?
Yes.
I have nothing further, Your Honor.
Let me clarify with you, ma'am, because I am a little confused.
Yeah.
You can always vote for life, is that correct?
Yes.
Could you vote for death?
Well, I can't, I don't see what the circumstances or aggravators could be that would allow me to say, oh, wow, that is a sentence of, like, I don't foresee, I don't know what that looks like.
Okay. So you just can't see yourself voting for death? Is there any case type of case that you can think of where you would vote for a death sentence?
Hannibal Lecter.
Hannibal Lecter?
Yes.
Good choice.
Yeah.
Short of that, is there anyone, what is it about Hannibal Lecter?
It was grotesque, it was vile, it was admitted, it was... there was no reform.
Short of that, can you see yourself voting for death? I'm not trying to push you into one.
And I don't know how, and I don't know,
I'm thinking, there aren't any, I don't follow the news. I don't necessarily look at Law&Crime or any of those. I don't look for morbid things, so I don't think so. I don't think so.
Thank you, ma'am. Let me see the attorneys at the bench. 1 second, please.
Okay.
All right, ma'am, I'm going to excuse you from this case. I don't think this is the case for you. We appreciate your willingness to serve and your being here today. You are free to go. Thank you so much. All right, let's bring the next group in. Can we fit, what? We may have what? While we're assembling these folks and getting them straightened out and waiting to see if we have a incident that interrupts us. Okay, well, I can hear it. I did look at the Allen versus State case cited this morning by the state, 322 Southern 3rd, 589. Can you hear me? 221 Florida Supreme Court. I also pulled the statute. Well, I printed it just so I'd have it in front of me. 921.141 Florida Statutes, subsection 2.2. The Florida Supreme Court has ruled very clearly that the use of the term recommendation of death is not reversible or fundamental error. It cites to the statute. The statute itself says in subsection 2, directing the jury unanimously find at least one aggravating factor, comma, the defendant is eligible for a sentence of death, and the jury shall make a recommendation to the court as to whether the defendant shall be sentenced to life imprisonment without the possibility of parole or to death, period. The recommendation shall be based on weighing all of the following, colon. So at this point, you're going to laugh, but I don't remember what the objection was. Oh, the objection was to the state using the term recommendation. I find that based on the Florida Supreme Court's ruling, at this point, the law in the state of Florida is that the state may use the term recommendation. Yes, Ms. Miller?
I have a case for your honor. If I may approach.
Yes. Is it older or newer than the case?
It's Hurst. I just wanted to clarify something the court said earlier. It's Hurst v. Florida, the Supreme Court of the United States case. I also have a highlighted copy for the state. The holding in that case held that Florida's capital sentencing scheme, under which an advisory jury makes a recommendation to a judge, and the judge makes the critical findings needed for imposition of a death sentence, violates the Sixth Amendment. And so I think there is a lot of confusion about SCOTUS Hurst and FSC Hurst. SCOTUS Hurst did not discuss unanimity. Rather, Justice Sotomayor held along with the rest of the justices, that Florida's death penalty scheme was unconstitutional because it was a recommendation. It's also violative of Caldwell. And I agree with the court that the statute hasn't been amended, but the standard jury instructions have. So the Florida Supreme Court took out purposefully every reference to recommendation in the standard jury instructions that are given in capital cases. So there is standard jury instructions promulgated by the Florida Supreme Court and the statute. But given Hurst v. Florida and Caldwell and the fact that the standard jury instructions were amended to remove recommendation, I think it's improper for the state to make any suggestion that to minimize the jury's role as a sentencing body.
To repeat what I said about Hurst, the Hurst decision did not address the use of the term recommendation by the state. The Hurst decision was that our capital sentencing scheme was unconstitutional because it left the judge with the ultimate decision of death. And the statute was amended so that a judge cannot impose death unless a jury votes 12-0. And I don't think Hurst is relevant to the issue before me, which is the Florida Supreme Court, which is my governing body, is telling me that the state, it is not fundamental or reversible error for the state to use the term recommendation. Am I encouraging them to use it? No, but it's not fundamental or reversible error. That's the ruling of the Florida Supreme Court in 2021. It's the ruling I'm bound by. And I will say again, the jury instructions have not been amended, but they certainly have a number of cases that have come down that this court at least wishes they would clarify what they want in those jury instructions. But that's for another day. All right, folks, let's bring in whatever juror I said. Who did I say? Well, let's bring them all in, actually. Yeah, I need to, yeah.
trial is going to do an answer truthfully all questions asked of you as a perfect jury so that we have.
All right, have a seat, everyone. All right, we found out that some folks can't hear me while I'm wearing this mask. I'm taking it off to make sure you can hear me. So I'm sorry to keep everyone waiting. I'm sure you understand this case is extremely serious. It's taken a little bit longer today than we had hoped, but we'll try and get you out of here as soon as possible. I do not want to have to bring you back tomorrow, so I'm willing to work late. If anyone has an issue, let the deputies know, okay? They'll talk to you about it once I send you back into the jury room. What we're going to do today is I'm going to give you some preliminary information and instructions about this case, and then I'm going to send you back into the jury room, and we're going to talk to you one at a time on certain topics. I'll give you more information about that in a minute. Let me start by telling you a little bit more about the case. As I told you, this is a death penalty case, and so we do things a little bit differently in these cases. They're called capital cases. I'm going to start by telling you what Mr. Loyd is charged with. Mr. Loyd was charged by indictment. This is a copy of it in my hand. An indictment is a piece of paper that tells someone this is what you're being accused of doing. You must tell defendants and people what it is you're charging them with doing, what you're accusing them of doing. This is how Florida does it. This is not evidence of guilt. You cannot take it as evidence of guilt. And by that I mean just because somebody's been charged with a crime doesn't mean you can assume they're guilty of it. The state has to prove guilt beyond a reasonable doubt. All right? So in this case, Mr. Loyd is charged with count 1, first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. Count 5, possession of a firearm by a convicted felon. Again, those are the charges against Mr. Loyd. Nothing has been proven against him. Count 1 is the capital charge, first-degree murder of a law enforcement officer. That's the only charge that carries the possibility of a death sentence. We do not have an automatic death penalty in the state of Florida. Let me explain to you how these cases are tried. Part 1, or phase 1 of the case, is what we call the guilt phase. The guilt phase is conducted pretty much the same way as we do every other criminal case. You're going to be asked to listen to the evidence and the testimony presented in the case. Testimony is evidence, but I'm talking about like physical evidence that might be presented, videos, photographs, documents. Witnesses testify from this box to my right. You're going to be asked to listen to that testimony. Once you've heard all of that, you will receive detailed jury instructions from me as to who has to prove what and what the law is in this case that you must follow. When you determine what the facts are, you apply the facts to the law as I give it to you. You will then be asked to return a verdict of guilty or not guilty on all counts, and your verdict must be unanimous on all of the counts, meaning that each juror must agree on each count either to acquit or convict. The burden of proof on the state is the same in the guilt phase of a capital case as it is in every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you will receive on reasonable doubt is identical to the one given in all other criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in the guilt phase of this case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree as well as any other offense charged, or guilty of a lesser included offense, or not guilty. And we expect you as jurors to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, you will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That is known as the penalty phase of the case, and it only happens if there is a conviction for first-degree murder. If it does happen, there's a special set of rules and instructions that I will give you at that time for you to follow. Right now, all I'm going to give you is an overview of what happens in a penalty phase. Because the death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The prosecutor is going to present and rely upon things called aggravating factors. They are by statute limited to 16. The state is required to prove aggravating factors beyond and to the exclusion of a reasonable doubt. And they are the reasons they believe the vote should be for death. The ones that the defense relies upon are called mitigating factors or mitigating circumstances. Mitigating circumstances do not need to be proven beyond a reasonable doubt. A mitigating circumstance need only be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background or character or circumstances surrounding the offense. They are offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without the possibility of parole means exactly that. The defendant will die in prison. The state of Florida does not have parole. Before you may vote that the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. If the jury finds unanimously that the state has proven one or more aggravating factor beyond a reasonable doubt, you can then begin the process, then death becomes a possible sentence, and you can then begin the process of weighing aggravating factors and mitigating circumstances to determine the proper punishment. Now, this is not a mechanical or mathematical process. You're not to go back there and say, well, there's this many aggravators and this many mitigators. I've added them all up, so this side wins. That's not how you do this. Weighing aggravating factors and mitigating circumstances is as follows. The law contemplates that each of you may view those differently, and you may give them different weights or values. In other words, you may find one more important than the other. You may find some not important to you at all, some greatly important. But each juror individually has to weigh them and decide which ones they believe are the ones that are important to making their decision. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, that vote must be unanimous. All of the jurors must agree to that one. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating the jury unanimously agrees the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility for parole. This is just intended to give you a broad outline, as I said, because none of you have any experience with this, and we need to know that you're able to go through the process if it should become necessary. Let me also say this. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another that this is a case that justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility. We're going to be asking you some questions about this procedure. We're going to ask you about your feelings about the death penalty. Are you someone who has a religious, moral, or personal objection to it? Are you someone who just would never impose death regardless of what the law is? On the flip side, are you someone who thinks that death should be the automatic sentence for first-degree murder? First-degree murder is the premeditated, intentional murder of another person without any legal justification. There are some people who believe that the sentence for that should automatically be death. It's not the law in the state of Florida. But if that's how you feel, we need to know that. We're going to ask you if you think you can go through that process of listening to the aggravators and the mitigators with an open mind and weighing them before reaching your individual vote as to whether life or death is the appropriate sentence. Please be aware of the fact that while many of you many people do have strong feelings one way or another about the death penalty, those feelings do not disqualify you to serve as a juror so long as you can put them aside and follow the law as I instruct you. I told you what some of the questions are just so you can be thinking about them while you're in the jury room. I'm going to switch gears now to insanity. Mr. Loyd has raised the defense of insanity in this case, not guilty by reason of insanity. The jury instruction is rather long, but I'm going to give you the definition, and we are going to ask you some questions about how you feel about this type of a defense. A person, and one other thing, this is the only time that the defense has to prove something in the guilt phase. It's their burden to prove insanity, and they have to do it by clear and convincing evidence. A person is considered to be insane when he has had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. So again, we are going to be asking you about your feelings about that type of a defense and whether you can keep an open mind about it. And lastly, I have a statement of the case to read for you all. On the morning of January 9, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last portion I just told you about, the conviction on the killing of Sade Dixon, cannot be used by you to determine whether or not he's guilty of this case. It's not relevant to whether or not he's guilty of this case. And we're going to be asking you some questions about this and whether you can put it out of your mind in the guilt phase. All right? Okay, folks, now I have a couple questions for you. Just raise your paddles in response to this. How many of you have heard about this case prior to being called to jury service? Just raise your paddles. When I call your numbers, you can put them down. 56, 58, 1, 9, 13, 14, 18, 22, 25, 27, 28, 29, and 37. Okay, those of you who raised your paddles, how many of you have formed an opinion as to whether or not Mr. Loyd is guilty based on what you've heard so far? 58, 9, and 37. All right, I have one more question for you all. Are there any members of this panel who have a moral, religious, or personal objection to the death penalty? 37, 5, 7, did you have yours up? Okay, 22. All right, thank you. Okay, folks, here's what I'm going to do. I'm going to start with the juror in seat number 56. The rest of you can return to the jury room. I'll be right with you and just as quickly as I can. There's coffee in there. Feel free to make as much as you'd like. Let the deputies know if you have any issues with remaining late today. Okay, good afternoon.
Good afternoon, Your Honor.
How are you?
I'm doing well. Yourself?
Good. Did you talk to the first DCA?
I did.
And?
The clerk of courts informed me that they have never seen a motion to continue oral argument for this specific reason. She suspected that they would probably be willing to grant that continuance, but she said she couldn't make that call. Only the judges could, of course, and file it at the appropriate time, and it would be one for their books, too.
All right. Tell me again when the first DCA arguments are.
I have one on November 4th that will be in Jacksonville, and then one on November 17th that will be in Tallahassee.
Okay. All right. You're an attorney by profession. Have you ever practiced criminal law?
I have handled a couple of criminal adjacent appeals, one of which was at the Florida Supreme Court at a pro bono request by the court, but I have never practiced in criminal trial law.
And the criminal appeals you handled, were any of them death penalty cases?
Absolutely not.
Okay. You said you'd heard about this case. How have you heard about it?
I'm a reviewer of the news. I read the Orlando Sentinel Daily, get the subscription, Channel 13. This case was not missable if you get the daily news.
How much do you know about the case?
I'd say the summary you gave more or less comprises what I know. I might recall a couple of other details perhaps, but nothing of significance, I would say.
There's nothing that's jumping out at you that you recall?
Other than the, reaction of people afterwards.
Okay.
And the, momentary fear that occurred during the week when people were uncertain as to the location of the defendant.
So I assume you were talking to colleagues and friends and family about it?
That's correct.
All right. Based on all of that, did you form an opinion as to whether or not Mr. Loyd is guilty?
I did not.
Okay. Did you form an impression as to whether or not he's guilty?
I would say that I would probably have believed, based upon that news assumption, that more likely than not, yes, but beyond a reasonable doubt, no.
Okay. All jurors must be able to presume Mr. Loyd to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you believe that you could do that in this case?
I do.
And you think you could hold the state to their burden?
I would.
Okay. So let me talk to you a little bit about the death penalty. Do you have any personal, moral, or religious objections to the death penalty?
I do not.
Okay, you didn't indicate you did, but I just wanted to make sure. Are you someone who believes that if you're convicted of first-degree premeditated murder, intentionally killing someone, you should automatically be sentenced to death?
No, I am not.
Right. Do you believe there's any type of case where someone should automatically receive the death penalty?
That's a difficult question. Yes.
Okay.
I would say that a scenario of serial killers, child killers, it would be hard not to believe that it should be at least considered in those cases.
Okay.
But the word automatic troubles me, and I would still say no.
All right. this is the death of a law enforcement officer. Is there anything about that that would cause you to automatically vote for death in this case?
No, there is not.
What about the prior conviction for the murder of the girlfriend and the unborn child?
I understand that that is not what the jurors here are intended to do.
All right, so, and when I ask automatic, let me clarify. I'm talking about, I mean, once you've heard the evidence
Right.
and the aggravators and the mitigators, your decision is your decision.
Sure.
I'm talking about now, before this has even started, you haven't heard anything, and you're thinking, you know, if I convict him of this murder, I'm going to sentence him to death because of that murder. No?
I would not hold that
All right.
opinion.
You heard my description of what it is you have to do as a juror, weighing the aggravators and the mitigators. If you went through that whole process, you've listened to everything, and you thought that you're convinced that the appropriate sentence is life without parole, can you impose that?
I could.
If you are convinced that the appropriate sentence is death, can you impose that?
I could.
All right. Do you have any doubt in your mind about your ability to do any of this?
I don't.
All right. The insanity defense. You know, he's raised the insanity defense, burdens on him in the guilt phase. But say you got to the end of the guilt phase and you thought, yeah, they convinced me he was insane. Can you reach a verdict of not guilty by reason of insanity?
Yes, I could.
And lastly, can you put the conviction for the murder of Miss Dixon and her unborn child out of your mind during the guilt phase?
During the guilt phase, yes.
All right. Thank you very much. I don't have any other questions for you. Mr. Williams, you may inquire.
Your Honor. Good afternoon.
Afternoon, Mr. Williams.
So during the general voir dire, you made it clear that you knew myself and Judge Marquez prior to coming in today?
That is
right?
correct. That is correct.
And is it true that you were the president of the Orange County Bar when I served on the executive council?
That is correct.
Do you recall us ever having a conversation about this case specifically?
I do not believe we ever have.
Do you recall us ever having a conversation even about the death penalty in general?
I feel pretty certain that we have not.
Okay. Anything about the relationship, such as it is with myself or the court, that causes you any concern about your ability to be fair and impartial?
No.
So you answered the judge's questions about the death penalty, but I want to ask a very general question with the hopes you can provide us more information. What are your feelings about the death penalty?
I believe that the death penalty should be rare in its application. I am concerned about its use because I understand the economic impact of a death penalty case versus a non-economic impact. I understand the racial implications of the death penalty as applied in southern states. And so I have concerns about the death penalty being invoked in all cases. But I balance that with the reality that in the appropriate case, it should be an available tool to the justice system. So I'm a conflicted individual on the death penalty.
That last statement, that it should be an available possibility, is that a personal feeling you have?
That is a personal feeling that I have.
Okay. You filled out a questionnaire when you came in,
I did.
and on the questionnaire it says you've actually been a juror before.
It's actually true. I've been a juror twice.
Twice, okay. How long ago for the first one?
They were both about a decade ago. It happened back to back, one year apart from each other. And it had been 20 years before that I had ever even made it into a jury pool.
Going in order chronologically, first in time, criminal or civil?
They were both criminal trials.
Okay, do you remember the nature of the crime in the first one?
I do. It was a petty theft. Stole a Xbox from a Best Buy and ran.
Okay, and the second one?
The second one was a alleged molestation by a friend in the same house kind of circumstance.
In the molestation case, was the alleged victim a child or an adult?
They were both underage.
Okay. Without telling me the verdict, did you reach a verdict in the petty theft?
No, it was mistried.
Because of actions by the jurors or something else?
Something else, there was a piece of evidence that everyone said didn't exist, and suddenly we were in the juror room for an extra hour, and when we came out, Judge Jewett kindly thanked us for our service and told us we were free to go.
Okay, and then the second case, was a verdict reached?
In the second case, a verdict was reached. I had a strong suspicion that I was juror number 7, and I was, so I did not actually get to reach that verdict.
You were the first alternate.
I was the first and only alternate in that case. Pre-COVID, we only needed 7.
Anything about your experiences, and I'm more focused on the second case, anything about your experience as a juror in that case that sticks out in your mind, positive, negative, or otherwise?
I was impressed with the work and preparation done by both sides on that case. You know, it was kind of eye-opening to get to experience that as a juror. I was glad to have had the experience. But as far as the actual trial itself or the defendant, no, nothing had changed my perspective on the world.
Because of the nature of one of the potential defenses, I need to ask you this question. Have you or anyone close to you ever suffered from mental illness?
I had a grandma on my dad's side who, you know, was somewhat mentally unstable. For that matter, my grandfather on my mom's side suffered from Alzheimer's at the end of his life. You know, so both had some degree of mental illness issues, but nothing that I think came close to the category of insanity.
There are people in our society and maybe even our community who believe that mental illness is not real and or is an excuse to justify certain behavior. Would you fall into that category?
No.
You agree that, I take that to mean that you believe mental illness is a real thing.
Mental illness is definitely a real thing.
And if presented with evidence by the defense that met their burden, could you find Mr. Loyd guilty, not guilty, by reason of insanity, even if that meant absolving him of a crime, legally?
If the evidence proved what the instruction required it to prove, then yes.
Can you think of any circumstance where you would be unwilling to withhold judgment on a potential sentence in this case before fairly considering any mitigation that the defense were to present to you?
No, I'm always going to listen.
To anything, whether or not you believe it's important or not? Ultimately.
I'm always going to listen.
Okay. The last question I have, sir, is there anything in your life or background that you think we should know about you, given that we're trying to select the most fair and impartial jury in this particular case for Mr. Loyd?
I just think it's important in the, you know, making sure everyone's aware of everything, that when you described our relationship, that it must be noted that we both received professionalism awards at the exact same time, 22 floors below where we are right now. There will be pictures from that event, and I just thought that that's something that people should know about before any decisions on me are made.
I had totally forgotten about that. Yes, sir. Anything about the fact that we received not the same award, but the same class of award at the same time that you would think would prevent you from being fair and impartial in this case?
By definition, no.
Okay. Thank you, sir. Thank you, Your Honor.
Thank you, Mr. Williams. Ms. Miller, you may reply.
Hello.
Good afternoon.
I'm going to pick up where you all left off.
Sounds great.
Obviously, you introduced or greeted Mr. Williams by name,
That's correct.
and you have a personal relationship with him outside of this courtroom.
Outside of this courtroom, that is correct.
And we've discussed a few of those circumstances in which you've interacted as a member of the Orange County Bar Association. You were both on the executive committee. You were both received commendations at the same time. Any other social interaction with Mr. Williams?
It would all be related to the Orange County Bar Association, that I would have run in the same OCBA Law Day 5K as Mr. Williams. I would have been far, far behind him.
Same.
The same. And we would have both attended the Legal Aid Breakfast of Champions at the same time. I don't believe we were at the same table, but that would have been possible. So things of that nature. I've never gone out to a meal with him or that I can recall, that would be, at least it wasn't a bar function event.
Right. And fair to say you don't know myself, I'm Allison Miller, or any of Mr. Lloyd's other attorneys?
I don't. I would like to change that in the future. It's nice to meet you all.
Sure. You obviously brought up on your own a recollection of Mr. Williams receiving a professionalism award.
That's correct.
So fair to say you consider Mr. Williams to be a professional?
That is absolutely correct.
You have an opinion of him as a lawyer other than just what you've observed in the court?
That's fair. I do know him to be a professional.
Would you agree or disagree that if you were Mr. Lloyd, you might have some concerns about yourself serving on this jury, knowing your relationship with Mr. Williams?
Objection.
That's proper.
Rephrase the question.
You appreciate sort of the sentiment of, do you or would you have concern if you were on our side?
That's a difficult question to answer. I've thought about that, whether or not that would be. I know that I would listen to the evidence and apply the laws instructed by the judge and keep an open mind. But whether your client would know that I would do that, I really can't say.
Do you think the state starts out a little bit ahead because of your relationship with Mr. Williams?
I don't, but that's because of me. I could understand why you might think differently.
I gotcha. Let's shift to the First District Court of Appeal.
Sure.
This is a tough call. Obviously, you'd move for continuance if you were selected.
That's without a doubt.
It stands to reason, or we'd at least like to hope, that the judges would grant that.
I genuinely believe they would. They understand the importance of something like this, and the trick would be phrasing the motion in a way that didn't provide more information than would be required, but we'll cross that bridge.
Like hint, hint, nudge, nudge, yeah. I've been selected.
In a very important case, yes.
Gotcha. Is that something that would be weighing on your mind?
Well, no. I mean, it would until I file the motion, but once I file the motion, I am, whatever I'm being asked to do, I'm going to do to the best of my ability.
Okay. But when I say would it be weighing on your mind, to the extent that it would be distracting you from participating fully in these proceedings?
Sure. I really don't believe so.
Okay. Switching topics again.
Sure.
The judge asked you if you had any religious or moral objection to the death penalty. And correct me if I'm wrong, but when you said, I do not, it appeared to be kind of a hesitation or a clip in your voice. Would that be fair?
That is fair.
Why? What comes to mind?
I think what I said in the response to the next question, I believe that Mr. Williams asked me, was what I was debating whether that was an answer to that question, because I don't have a religious objection to the death penalty, and my moral objection is more based upon those other factors that I think that, I've mentioned that the prejudice that in deciding which people get charged with the death penalty, which ones don't, troubles me. And then there's the economic realities that, perhaps our civil justice system would be better off if we just never used it because of how much smoother and cheaper and easier these cases would be. But there are those cases that make me think otherwise. And so you asked the question, that's all of that was in my mind at the same time, and I paused before I responded.
Okay. I thought you were going to say, I just wanted to be sure that when you said, indicated some sort of hesitation,
sure,
that's what you then went to expand upon.
understanding that premeditated first-degree murder is the intentional killing of an innocent victim, the judge asks you if your penalty, once you found somebody guilty of a crime like that, without legal justification, excuse, or defense, is automatically the death penalty. And you said no.
And that is correct.
Okay. In considering whether life or death is the appropriate penalty, something like the effect of racism on the defendant, is that something you believe you would be able to get meaningful consideration to? And when I say that, I mean, you're a lawyer, you understand standards more or burdens more than most,
Sure.
right? But so meaningful consideration is more than just listening to a passing thought and ignoring it.
That's correct. I would need to hear the specific application to the individual as opposed to a generic, because racism exists, therefore you shouldn't do it. But you know, that I don't know that I would agree with that. But if the defense presented mitigating evidence that convinced me that as applied to this individual, it did merit a mitigating consideration, I would listen and I would apply it in context of the other evidence.
Okay. What about the defendant having a troubled or challenging background as a child?
I would understand that to be a mitigating circumstance.
But is that something you believe you would be able to give meaningful consideration to?
Again, it depends on what evidence is presented, but yes.
Okay. And that's where, you know, some people, as the judge indicated, say, in my heart of hearts, once I've made the determination that a defendant is guilty of the crime of premeditated first-degree murder, let alone the first-degree murder of a law enforcement officer,
Sure.
I know truthfully I'm just not going to be able to give meaningful consideration to these things you're talking about. And so the question I have is, once you've made a determination, if you do, that a defendant is guilty of the premeditated intentional killing of a law enforcement officer, is death automatic, or can you still consider those things?
I would absolutely still consider all of those things.
Okay. And forgive me if you already know what I'm about to discuss, but since you haven't practiced crime as a trial lawyer, indulge me. Death is never required, not in any case. Not in this case, not in the worst conceivable case you could imagine.
I understand that and agree with that.
Okay. And that's, you know, if one juror decides that life should be the verdict, then life will be the verdict. Are you comfortable with that?
I am. I mean, I can understand the state making a different rule, but that's not the rule Florida's made, and I'm comfortable with that.
And, you know, we talk about mitigation.
Sure.
And so I define that as, it's a legal term to mean why any one person would choose life or not choose death. And it doesn't have to be unanimous. It can be unique to each juror, and it can be even something seemingly small, like a smile you observe between the defendant and his mother, where you just say, I'm not imposing death. I observe that, and for me, I assign the weight of life to that. And that's okay. You okay with that?
I'm not sure that specific episode would make
Sure.
the mitigating factor for me, but I definitely understand and agree that and I understood Judge Marquez's, you know, preliminary statement about how the state only gets these 16 factors, and you've got the whole any life experience you want to give to us, and I would listen to anything that you and your team provide us to know. And that's a difficult job for each and every individual juror.
Sure.
And every one juror gets to make that call, and I think that's pretty amazing.
And it's interesting you brought this up because, you know, we tend to think the state proves aggravators and the defense proves the mitigating circumstances. Mitigation can come from the state's case. You may see something in the state's presentation or case in chief in first phase, penalty phase, and think, you know, I find that to be mitigating even though it's coming from the state.
And that's fair. When I said from your team, that would be true. It could come from any source. That's fair.
And that in order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments have to be reflected in this courtroom and on the verdict form.
I get that.
And you are certainly not going to bully or badger another juror to agree with you.
That's fair, and I think that's a concern when you have a legal professional on the jury, that they could try to utilize their knowledge to intimidate or change the minds of others, and I would be acutely aware of that and work hard not to have that occur.
Right, I think that's fair. It is a possibility that other jurors would look to you for guidance once they knew you were a lawyer.
Right.
And still, though, Your opinion, while valuable, is not any more valuable than any other juror's individual moral assessments as to whether or not Mr. Loyd lives or dies.
That is correct. I'd say I think I followed that rule that I kind of self-imposed rule that I just said in my other two jury experiences. I didn't get to actually deliberate on either, but even during our being in the sequestered room, that I made sure, people would sometimes ask me questions, and I might say, just general procedure issues, but I would purposefully never try to guide them on anything with the case.
And that, we talk about deliberating, and that you have the good fortune, although that is strange that a lawyer such as yourself has been selected to serve on so many juries.
I was very surprised myself.
But deliberate means to carefully consider. And so there are going to be jurors that say, I just can't articulate why, but I know for me the verdict is life. And that's okay too, right? We'll chat people by profession, and not everybody is the same or is able to articulate why they came to a certain determination. And if you have reached a verdict for life and it's not being respected by your fellow jurors, you have the right to say, we're done. Deputy, please get the judge. We've reached a final verdict. Can you do that?
I could do that.
I have just a moment, Your Honor?
Yes, ma'am.
I have no idea.
Either side have a motion?
No, Your Honor.
We'll be right with you. All right, we are sending you through for the final round of questioning. And we will be picking the jury. Yes, I knew you would be overwhelmingly excited. All jurors have been very excited by that announcement. We will be picking the jury that day.
Okay.
So, a couple of things. Number one, you're now a purple dot.
I'm a purple dot.
You're
I've
a
moved
purple
up from
dot
blue.
now when you're listening for when you're supposed to come back to the courthouse. I have no idea when that's going to be. I know it won't be before Wednesday, so don't call before Wednesday. It'll
Okay.
probably be next week, but I'm guessing, okay?
I do have a deposition on Thursday of my favorite client, the supervisor of elections.
I do not think that you should be concerned
Okay.
about that
Thank
either.
you.
So we're going to give you a purple dot and a sequestration package. When you come to the courthouse for that final selection, you're going to need to have packed a suitcase. Just leave it in your car, because if you get picked, you're being sequestered right then and there. I will make arrangements for you to inform the first DCA of that if it happens.
Okay.
But like I said, just leave it in your car in case you don't get
Sure.
picked.
If I'm told by a judge to bring my toothbrush, I will bring my
Bring your
toothbrush.
toothbrush, yes. Bring your, whatever else you need, because you would be going that day.
Understood.
There's a sequestration package in there that explains it all to you and gives you a list of things we think you should bring with you. All right? Any questions?
Not at this time. Thank you, Your Honor.
All right. Have a good afternoon.
I can take that from you as well.
Absolutely. Oh, it is 4:30. Yeah. All right, folks, your real time is going to switch. We're switching court reporters. Let me know when you're ready, Bree. Okay. We're good? That's pretty impressive. All right, let me look. PN2, there it is. All right. All right, ladies and gentlemen, let's bring in the juror in seat number 7 from panel 5, and it's going to be juror 209. Good afternoon. How are you?
I'm doing all right.
I have 2 number 7s in here. Did you tell me you have an objection to the death penalty?
That was the other 7.
That was the other 7?
Yes.
Okay. So we're going to be asking you some questions.
Yes.
No magical answers to this, no right or wrong. We need to be able to determine whether you can do your job as a juror or not. So it's really important that you just tell us the truth and answer the questions. That's the whole point of these questions, okay?
Understood.
Let me start with just confirming, you've never heard anything about this case?
Correct.
All right. And do you have a moral, religious, or personal objection to the death penalty?
No.
Do you believe that death should be automatic in certain types of cases? A death sentence? Yeah.
Not automatic, no.
No. All right. So let me get a little bit more detailed with you. In this case, the first count involves the death of a law enforcement officer. If there was a conviction for first-degree murder, which is the intentional killing of someone without legal justification, you don't have a defense to it, okay? And you have to find that beyond a reasonable doubt. Done that, now you're in penalty phase. It's a police officer. Would you, right now, having heard nothing, okay? I'm not asking you about after you've heard all the evidence and everything.
Okay.
Would you automatically vote for the death penalty because it was a police officer?
No.
Okay. And I told you about the previous conviction for the murder of Ms. Dixon and the unborn child.
Yes.
Would you automatically, right now, you haven't heard anything, would you automatically vote for death because of that?
No.
All right. You heard me describe the procedures for jurors deciding whether to vote for death or life. You understood all of that?
Yes.
Sort of, yeah. We give it to you in writing.
Right,
so.
yes, I believe.
But you're going to be weighing aggravators and mitigators, all
Correct,
right?
yeah.
And you have to decide which ones are important to you. No one can do that for you.
Understood.
But at the end of that, you've weighed them, you've heard the trial, you've heard all the evidence, there's a conviction. There's been some confusion about this, so that's why I keep saying it. There's been a conviction for first-degree murder, intentional killing of another person, no legal justification for it, but you're weighing aggravators and mitigators. If all of that process led you to believe that life without parole was the appropriate sentence, could you vote for that?
Yes.
If it led you to believe that death was the appropriate sentence, could you vote for that?
Yes.
Okay. Can you put out of your mind the prior conviction for Ms. Dixon and the unborn child and the life sentence in deciding whether or not Mr. Loyd is guilty of these charges?
I believe I can.
Okay. And Mr. Loyd has raised the defense of insanity. That burden is on them, on the defense. It's the only burden that they have in a guilt phase. Normally, the state has the entire burden, but if they want to prove insanity, they have to prove it. It's the end of the guilt phase. It's time to decide whether he's guilty or not. You believe that they've proven he was insane. Could you vote not guilty by reason of insanity?
I could, yes.
All right, thank you, sir. I don't have any other questions for you, but the state, Mr. Williams, has, and then the defense will have some questions for you. You may inquire.
Thank you, Your Honor. Good afternoon, sir.
Afternoon.
So what grade is it that you teach?
6th grade.
Oh, that's a tough one.
Well, and their last full year was 3rd grade, and so now we're here, so
Right.
yeah, we're
So
playing catch up.
I take your statement to indicate that it's been a tough year.
It's tougher, yeah.
Oh, okay. So can you just give me your general opinion about the death penalty?
I think in some cases it does warrant it, and in some not so much. I haven't really, really studied it, but
Sure.
I've never thought it should 100% be not there or there,
Okay, and that sort of as a thumbnail is to have a law looks at it, right? You have to consider certain things first. Does that make sense based on what the
I'd say
judge is
so,
saying?
yeah. Yes.
Okay. Before we talk more about that, I wanted to get a sense from you. 1 being you don't want to be here at all, and 10 being you're super excited about the idea of sitting in the chair. Where would you put yourself?
Well, definitely not. I mean, excited is not the word. I know that this is necessary.
Okay.
I'm not. When that's what I would need to do, I would do it. My degree was public administration, so I actually, I had to watch 12 Angry Men as an assignment, so a little bit, but yeah, no, I don't know if it's, in the middle of 5, indifferent, I would have to do it, I guess.
Okay, fair enough. We have answers from the questionnaire you filled out when you
Yes.
first came in, and one of the questions is, have you or a member of your family been accused, a complainant, or a witness in a criminal case? And you said yes. Can you tell me what circumstance you were referring to?
Yes, so my brother he recently moved to Pennsylvania, and he was, I guess he was abusing substances, and he ended up forgetting where he was and all that, and there was trespassing, and he went to, I think they settled or something like that, I don't know, but that's what happened, was with him.
And is that the only circumstance you were referring to?
Yeah, that was it.
What you know about that situation, did it come from your brother? From some other source?
It was from, I was there when he was not coherent, so it was from doctors.
You were actually present for the incident?
It was directly after.
Okay.
Yeah.
Anything about the way he was treated by law enforcement that you think was unfair?
No.
Okay. Anything about that situation at all that you think would prevent you from being a fair and impartial juror in this case?
No.
You also indicated that you have a friend or close relation in law enforcement.
Well, it's actually my brother's actual friend. I'm a friend by proxy, back in Martin County. It was where I'm from. And
Which county?
Martin County.
Martin County. Okay.
Yes, and that's where he is an officer.
Anything about that relationship that you think would prevent you from being fair and impartial in this case where a law enforcement officer was murdered?
No.
Okay. If selected as a juror, and if, this is a huge if, if the jury would unanimously find that Mr. Loyd had committed first-degree murder, and the judge gave you an explanation of what that means, then and only then would you all, the jury, be asked to listen to evidence and make a a recommendation on sentence, right? Render a verdict on sentence.
Right.
If you did that, the first thing that would happen if we got there was we would present evidence of aggravating factors. And those are things just like they sound. Things about the nature of how the crime was committed or sensitivities of the victim, or even things in Mr. Loyd's background that make this particular first-degree murder aggravated above and beyond one without these factors. Make sense?
Yes.
We have to prove at least one of those beyond a reasonable doubt to move past the next, to move to the next phase of the process. That second phase is where you consider the mitigation presented by the defense, and that is, could be anything in Mr. Loyd's life, background, or experience about his character that you believe that they will argue to you is a reason why life without the possibility of parole is an appropriate sentence. Does that make sense?
Yes.
Because there's only two sentences, potential sentences for first-degree murder in Florida, life without the possibility of parole and death. And then you would be asked to weigh the aggravating factors against the mitigating circumstances, and you would personally decide how important each one of those are, right?
Correct.
So when we say weight, it's really how important you think they are. And then if and only if you and the jury unanimously believe that the aggravators outweigh the mitigators, would you all be authorized to impose a sentence of death? Does that make sense?
Yes.
To vote to impose a sentence of death.
Right.
Anything about that process that you think would prevent you, that you could not go through, as I've described it?
No, as I understand it, we deliberate amongst ourselves as jurors,
right,
and come to a conclusion. Yeah, I could go through that process.
Now, ultimately, that final decision is a personal decision that you would reach. Do you understand that?
Yes.
So while you're encouraged to deliberate and speak to each other, you're not required.
Understood.
The key part of this whole process that we just discussed is the willingness to listen to everything. And when I say listen, I don't mean like, you know, sitting in class and your sixth graders are listening to their iPods while you talk. I mean like...
internalize.
Right.
Yes.
And give meaningful consideration to.
Yes.
Could you, and only you know the answer to this, could you give meaningful consideration to any aspect of Mr. Loyd's life or background that you heard about?
Yes.
Even if you didn't think it was important, ultimately, you could consider it.
Yes.
No matter what you heard about the aggravating factors.
I believe so. I think everything counts towards whatever it is you're going towards.
Right. And it sounds like you understand that is required of you if you're selected as a juror in a capital case.
Yes.
Okay. Have you or anyone close to you ever dealt with mental illness? And I ask that personal question only because of the nature of insanity the insanity defense.
Mental illness, straight out, I don't think so.
Okay.
I know some things can, I suppose, push one to temporary, status or whatever.
Okay.
I don't think so. No, not in my family, not really, no.
But in answering my question, I think you answered my second question. Is, do you believe that there can be insanity, and in fact, temporary insanity?
Yes.
So you're not one of these people, I take it, that does not believe mental illness is real?
I believe it's real.
Okay.
Yes.
If it were proven to you by the defense, could you find Mr. Loyd not guilty by reason of insanity, even if you knew it meant absolving him of criminal responsibility in this case?
If it was proven to me, yes.
Okay. Is there anything in your life or background, sir, that you think we should know about you, given that we're trying to select the most fair and impartial jury in this particular case? By way of example, some people say, my loved one was murdered 10 years ago, and I saw the case, and I can't be a part of this. Anything like that you can think of? I don't know that there is.
Not to my knowledge, no.
All right. Thank you very much, sir. Thank you, Your Honor.
Thank you, Mr. Williams. Miller, you're up.
Hello. I just wanted to ask for a little follow-up information. The judge asked you a series of questions.
and your answer was yes to most all of them,
Okay.
except for one, the judge asked, can you put out of your mind the prior conviction for Miss Dixon and the unborn child and the life sentence in deciding whether or not Mr. Loyd is guilty of these charges? And you said, I believe I can.
I can.
Okay, tell me why your initial answer was, I believe I can.
I mean, to emphasize that I can, if that makes sense.
Well, the only reason I contrasted
Right.
is because she asked you some other questions and you said yes. And so that one, it's.
But I know it would be difficult, or well, it would seem difficult for someone to put that aside. But when I said, I believe I can, I was attempting to add conviction to it to show that I really could.
Okay.
But I guess that might have been the wrong way to do that.
No, there's no right or wrong. That's just why I wanted to clarify with you.
Yeah.
The only oath you've taken right now as a prospective juror is to answer truthfully,
Okay.
right? And only you know what's going on inside of you.
Yes.
And so that's why we take this time to have this conversation about your feelings. And so understanding that first-degree murder is the intentional, premeditated killing of an innocent victim. A defendant thought about it, meant to do it, and did it.
Yes.
The judge asked you this as well. Is death the automatic penalty for that person?
No.
Why not?
The saying, it depends, applies. I know that there are things that can happen that can push people in certain directions. And, especially as a teacher, we have to see students, I mean, they may not act appropriate, but certain things happen to them that make it not their fault. I think no matter how old you are, or who you are, where you're from, that does still apply. That would be why I would say that.
Okay. What school do you teach at?
Westridge Middle School.
Say again, I'm sorry?
Westridge Middle School.
Westridge. Thank you. And that's where there are people that say, once I've found somebody guilty of the intentional premeditated killing of another person, that for me, death is the only appropriate penalty. And then the next question is, if that innocent victim is a law enforcement officer, is death the automatic penalty?
We're all people. I don't assign extra weight that would affect my judgment, at least. So the person being a police officer would not change my decision.
Okay. And when you say it depends upon the circumstances, right? And I just want to make sure we're on the same page. Are we talking about the circumstances that may make somebody guilty or not guilty of the crime of first-degree murder? Or are we talking about things that you might consider in the second part of this trial if we get there in determining if life or death is the appropriate penalty?
Objection.
Sustained. Rephrase.
I wish I could harken back. What did you say when you said, it would depend upon the circumstances? What was your answer there?
Depend upon the circumstances.
And what were you thinking when you said that?
Whether it's the mitigating factors or the aggravating factors, or the fact that there was a crime committed, I believe things push people in different directions.
That was it.
Whatever, I don't know exactly which one you're asking about, but.
I'm sorry, I wanted to capture that. Things that push people in different directions.
Yes.
I just want to make sure we're not talking about things that potentially could make somebody not guilty of the crime of first-degree murder. Does that make sense?
I'm confused.
Okay, what do you mean when you say things that push people in different directions?
I mean, what's happened to them in their life, what's going on around them, what have they, everything, if that makes sense.
Yep, I think I understand you better now.
Okay.
And I apologize.
No,
I just couldn't remember the exact phrase you used, and I wanted to capture that and ask you follow-up questions.
Okay.
Let me ask you, if the defendant had experienced the effects of racism, is that something you believe you'd be able to give meaningful consideration to? And when I say meaningful consideration, right, it's not just I've heard it and I'm dismissing it sort of simultaneously. It's something that you would be able to internalize and consider.
Well, yes.
How come?
Because racism is real. It can very much affect someone's life. I don't know, I mean, so you asked me, could I assign weight to the fact that if someone experienced racism, it would affect them? That's your question?
If you could give meaningful consideration to it, yes, sir.
Yes, and then you asked me why.
Right.
Because racism is powerful. I mean, I truly believe that. It's not good, it's bad, it's real.
I got it.
Okay.
Not everybody feels the same way.
Yeah, I understand, but yes, but that is my stance.
Okay, I didn't want you to think I was asking a simple
No, I
question.
understand.
Got it. How about the defendant's background, childhood, tough childhood? Is that something you think that you could give meaningful consideration to?
I could.
Okay. Let me just discuss a couple legal things with you, if you don't mind.
Okay.
Death is never required, not in any case, not in the worst conceivable case you can imagine.
Understood.
Okay? And that if one juror decides that life should be the verdict, then life will be the verdict.
Correct.
With me?
Yes.
And we talk about mitigation. It is just a legal term that means why any one juror would choose life or not choose death.
Understood.
And it doesn't have to be unanimous. It can be unique to each individual juror, and it can be something that's seemingly small, even like a smile that's observed between the defendant and his mother. And for that juror, in those circumstances, he or she says, I assign that the weight of life, and I'm just not giving a death sentence.
Understood.
You okay with that?
Yes.
Okay. And, you know, some people say, no, I need it to be something.
I understand that everyone is different. They can assign whatever meaning they can assign to anything. I understand that.
Gotcha. And sometimes these things can get contentious in the deliberation room. People have strong opinions and differing opinions.
Understood.
Right? And that the law requires, in order for a just verdict to be returned, all 12 jurors' individual moral assessments about whether or not Mr. Loyd lives or dies have to be heard in this courtroom.
Correct.
It is your duty, your responsibility, and your right to make sure your individual moral assessment is heard in this courtroom and reflected on that verdict.
Yes.
And if you come to a decision that the verdict should be life, and it's not being respected by your fellow jurors, you can say, we're done here, I've reached a verdict, go ahead and write that down. Let's get out of here.
I understand.
Can you do that?
I would do that if that was my opinion, yes.
And you certainly aren't going to bully or badger anybody to agree with you who has a difference of opinion.
No.
And you're not going to let anybody else do that to you.
No, my decision will be mine, yes.
May I have just a moment, Your Honor?
Yes, ma'am. All right, I just need to approach the motion.
No, Your Honor.
All right, sir. We're going to send you through to the final round of questioning.
Okay.
Let me take this off to make sure you understand me. So that means a couple of things. Number one, you're going to become a purple dot, giving up your blue dot. Okay?
All right.
Purple is for the final group. I don't know when you're being called back. I need to have a certain number of jurors to do that, and I haven't gotten there yet. It will not be, don't even bother to start calling until Wednesday, okay?
Okay.
So in this package that we're giving you, there's a phone number for you to call. Call after 5. Eventually, you're going to hear purple dots return on this date at this time.
So
Okay?
call back from Wednesday onward until you
Yeah,
hear.
just call. And I don't think it's going to be before next week, to be honest with you, but it's possible that it would happen. We're also giving you a packet that includes the sequestration instructions, and it gives you a list of things to pack. Because we're picking the jury from the final group when you come in, the purple group, we're going to pick the jury that day and we're going to sequester the jury that day. So when you come back, you need to be packed. Leave your
Understood.
suitcase in the car. If
Yeah.
you don't need it, great. If not, we'll go get it.
Right.
Any questions?
No.
There's also a letter in there for your employer.
Okay.
All right. All right. Thank you, sir. We appreciate your time today. Have a good afternoon.
Thank you.
So we're going to get the juror in seat 24, please.
From panel 5,
From panel 5, yeah, I'm sorry. I think that finishes up the 9 o'clock group.
58, Judge.
58's a 2 o'clock group.
I apologize.
No worries. It's hard to keep track.
See right there.
All right. Good afternoon, sir. How are you?
Good, ma'am. Yourself?
I'm doing well, thank you. Okay, welcome back. We have a few questions for you. I just want to confirm that you've never heard anything about this case?
Correct.
All right. And you don't have any personal, moral, or religious objections to the death penalty?
About the case I do, I was Marine Corps 6 years, so military, law enforcement, and first responders.
So in a case like this, if Mr. Loyd was convicted, it would be of the murder of a police officer. Do you think you could be fair and impartial, or you think you'd be biased in this case?
I'll be biased, Your Honor.
State. All right, sir. Thank you for your honesty. You're free to go. Thanks. That brings me to juror number 58. This is the 2 o'clock group and the last person on panel 5. Good afternoon, sir. How are you?
I'm fine, thank you.
All right, sir. Have a few questions for you. No magical answers to these. There's no right or wrong. We need to find out if you could do your job, if you were selected as a juror. So it's really important that you just answer the question very honestly. We're just trying to find out what it is you actually think and believe. And like I said, there's no right or wrong answers to that, all right? So you did say you'd heard something about this case, correct?
That's correct.
And that based on that, you had formed an opinion as to whether or not Mr. Loyd was guilty. Is that correct?
Yes, ma'am.
And what is your opinion?
All guilty.
Okay. Jurors have to be able to presume that Mr. Loyd is innocent until he's proven guilty. Would you be able to do that, or would you start the trial believing he was guilty?
Honestly, I'd start believing that he's guilty.
All right. Thank you, sir. State.
We move, Judge.
All right, sir. Thank you very much. This isn't the case for you, but we appreciate your honesty. You're free to go.
Thank you, ma'am.
Have a good afternoon. All right. That concludes panel 5. Juror in seat number 1, panel 6. What happened to panel 6? Have a seat, ma'am.
Thank you.
Good afternoon. How are you doing?
I'm good. How are you?
I'm well, thank you. I just have a few questions for you.
Okay.
Then the attorneys, excuse me, the attorneys may have some questions for you also. There aren't any right or wrong answers to these questions. The point of the questions is to find out whether you could do your job as a juror as required by the law of the state of Florida.
Okay.
That's why we're asking them. Your job is just to answer them truthfully, honestly, and fully. Don't worry about what the answer is, okay? So let me start by confirming, oh no, you did tell me you'd heard something about this case.
Yes.
What did you hear?
Only what was on the news at the time when it happened. Other than that, I haven't followed it, I don't watch the news regularly.
How much did you watch when it first happened?
Not much.
Okay, what do you remember from what you watched?
Just what he's accused of.
I'm sorry?
Just what he's accused of.
Okay. Well, based on that, and, well, let me back up. Did you also have some conversations with family or friends or coworkers about it?
No, ma'am.
So based on what you saw, did you read anything on the internet, anything like that?
Not that I recall, no.
Did you form an opinion as to whether or not Mr. Loyd is guilty?
No.
Did you form an impression as to whether or not Mr. Loyd is guilty?
No.
All right, jurors are required to be able to presume him to be innocent until and if the state can prove he's guilty. Can you do that?
Yes.
All right. You didn't indicate that you had any moral or religious objections to the death penalty, is that correct?
That's correct.
First-degree murder, in most cases, is premeditated murder. It's the intentional killing of another person without any legal justification. There's no defense to it. It's not self-defense. There's no defense to it. If someone is convicted of first-degree murder, it has to be beyond a reasonable doubt. But you found that person to have no legal justification for killing someone else. Is there anything about that alone that would cause you to without knowing anything else, other than what I just said, automatically vote for a death penalty?
No.
All right. The fact that this is a law enforcement officer in the first count, the first-degree murder count, is it, again, without hearing anything else, just sitting here right now, is there anything about that that would cause you to automatically vote for death?
No.
All right. The prior murder conviction that I told you about for Ms. Dixon and her unborn child, anything about that that would cause you to, as you sit here today, automatically vote for death?
No.
All right. You heard me explain the process to you all about weighing the aggravators. Again, weighing means you need to determine for yourself what is important to you in making your decision, what you find compelling or not compelling. That's totally up to you. You could reject every aggravator, reject every mitigator, accept them all. It's totally up to you. But in the end, you have to decide, listening to all the case and those aggravators and mitigators, what matters to you. If after you did all of that, you felt that life without parole was the appropriate sentence, could you vote for that?
Yes.
If you felt that death was the appropriate sentence, could you vote for that?
Yes.
You heard me tell you about the insanity defense. Burdens on the defense, only time burdens on the defense in guilt. This is just deciding whether he's guilty or not. If they prove to you that Mr. Loyd was insane at the time, could you vote not guilty by reason of insanity?
Yes.
All right. You also had raised some issues with your mom. Did you verify that someone could take care of your mom if you were sequestered as a juror?
Yes.
Okay. Do you have any issues with the 3 weeks of the potential 2 to 3 weeks of sequestration?
My only concern would be work, and I just wanted to know if when we're not in court or anything, would I be able to work?
Yes, ma'am.
Okay.
You can bring all your electronics with you, and absolutely. You're in a room with others who are also working or doing schoolwork, and the deputies are there because they have to confirm that that's what you're doing. But yes, ma'am, you can work. No worries. All right? Thank you. All right. I don't have any other questions for you, ma'am. The attorneys may. Mr. Buxman, you may inquire. Thank you.
Good afternoon, ma'am.
Hi.
Let me just start with a very general question. What are your general feelings about the death penalty?
I believe in it if the evidence shows that that should be the appropriate punishment.
Okay. But I believe you told the judge earlier that it may not be the appropriate punishment in all cases, but in some cases it may be. Is that an accurate statement?
That would be accurate.
Okay. The focus of this questioning here is basically to find jurors who can be open-minded and listen to all the evidence before making the ultimate decision. Would you be able to, if we get to a death penalty, sentencing phase in this case, the state would present evidence of aggravating factors. Those are factors that make this murder more egregious than others. Would you be able to, after hearing all the evidence of the aggravating factors, even if there are a whole lot of them, if they're really bad and they just offend you, would you be able to hold off judgment as far as what the proper punishment should be until you hear the evidence of the mitigating factors?
Yes.
Okay. Once you hear the evidence of the mitigating factors, would you be able to listen to the evidence regarding all mitigating factors and consider it and mull it over and focus on the evidence before you make a final decision in this case?
Yes.
Now, even assuming that a mitigating factor is presented to you, let me back up real quick. This is not the time to talk about what evidence applies and what the details are going to be of each aggravating factor and mitigating circumstance. That's during the trial. So it would be unfair to ask you to, what are your thoughts about this specific aggravator or mitigator, because you don't have any details about them yet. So my question is, would you be able to, regardless of what mitigating factor is presented to you, even if at first blush you're thinking, I don't know, that just seems kind of silly, you hold off judgment until you get all the evidence and details surrounding it before you make a decision?
Yes.
All right. Do you think Mr. Loyd deserves to have a jury that is open-minded and will listen and truly consider all this evidence?
Yes.
Okay. If we get to the point after you hear all the evidence of all the aggravating factors and mitigating circumstances, and if you felt that life was the proper punishment in this case, could you come back and say, I put life?
Yes.
If the evidence supported that in your mind?
Correct. Yes.
Now, looking on the flip side of that coin, not talking about a hypothetical situation where you're hanging out with friends and coworkers or something like that, talking about the death penalty, but a real life situation. If you felt that the aggravating factors outweighed the mitigating factors, you felt the death penalty was the proper punishment in this case, could you come back in here, raise your hand, and vote for a death sentence on another case?
Yes.
I have a few questions about the insanity issue that the judge just raised. Has mental health affected either you, a friend, or a family member in any way?
Myself, yes.
Okay. I'm not going to ask you the details of it, but obviously then you realize that mental health issues are real in some people in society. Did you seek treatment or therapy or things like that?
Yes, sir.
Okay. Would that experience with mental health issues prevent you from being a fair and impartial juror in this case in any way?
No.
Knowing that mental health issues may become...
No, it wouldn't.
Okay. Would you be able to hold off judgment as far as whether a mental health issue is actually present in this case, and if so, what the consequences of that are, until you hear all the evidence?
Yes.
Okay. Is there anything in your background, your life, or your belief system that you feel may make it such that you wouldn't be a good juror for this type of a case?
No.
Okay. All right. Thank you so much, ma'am. I appreciate your time.
Thank you.
No further
Mr.
questions, Turner.
Ms. Miller, you may inquire.
Oh, I'm stuck. Oh. It is a jungle. Hello.
Hi.
Just a few follow-up questions. Mr. Buxman asked you what your general feelings were on the death penalty, and you answered if the evidence shows that that should be the appropriate penalty, or the appropriate punishment, you believed in it.
Correct.
What does that mean?
If the evidence shows that the crime happened the way, per the law, that the death penalty would be one of the punishments, then I would agree that that should be one of the considerations.
And what does that mean? If the crime happens the way the law...
I'm not a lawyer, so I don't know how, I mean, beyond a reasonable doubt, yes, I understand that.
Okay.
If the evidence showed beyond a reasonable doubt that that crime fits that punishment, then yes, I believe in the death penalty.
Okay. And that's where, for some people, it becomes difficult, because of deeply held beliefs that we all bring into this courtroom, to be able to follow the law, right? And so that's why we have this conversation about your feelings, because the only oath you've taken at this point is to tell the truth, right?
Correct.
And so understanding that first-degree murder is the intentional, premeditated killing of an innocent human being, that defendant thought about it, meant to do it, and did it. Once you've decided that the defendant is guilty beyond a reasonable doubt of that crime, without any legal excuse, justification, or defense, is the death penalty the only or automatic penalty for you?
No.
Why not?
There could be other circumstances that would, maybe point to life imprisonment instead of the death penalty.
Do you think you are starting with the belief that death should be the penalty, and then either myself or one of my colleagues is going to have to convince you that life is the appropriate penalty?
No, absolutely not.
Okay, and when you say there are other circumstances, what do you mean by that?
Again, it would go back to the evidence and any reasonable doubt.
Okay, and so that's what I want to make sure we're clear on before we move forward. And I apologize if it seems like I'm asking the same question. If we're in the second part of this trial, right, where we decide, where the jury is faced with the decision of life or death, you have already made a determination the defendant is guilty beyond a reasonable doubt, right? So if we're here, we've already made that determination. Mm-hmm. And so that's what I wanted to make sure we were on the same page, is once you have decided a defendant is guilty beyond a reasonable doubt, no legal excuse, no legal justification, no defense, is death the only appropriate penalty?
I would say yes.
Okay, and why do you say that?
If it's beyond a reasonable doubt that he's found guilty, then I would say yes, that the death penalty would be the appropriate punishment.
Okay. And so once you've made that determination of guilt, for you, you're not going to be able to consider those other things that Mr. Buxman was talking to you about, like mitigating circumstances about his background.
No, I'd be able to take those into consideration as well, yes.
Explain that, tell me what you mean by that.
I guess I'm not understanding your question, maybe. But yes, you would have to take those mitigating circumstances into consideration when deciding whether it should be a death penalty or life in prison.
All right, let me intervene here because this is just about, let me go back over the procedure with you to make sure you understand it before Ms. Miller continues asking you questions. There's two phases to the trial. Phase number one is guilt, all right? In order to even get to phase number two, the penalty phase, you've got to get through the guilt phase. And you must find guilty of first-degree murder, premeditated, intentional killing with no legal justification. So you've rejected all defenses. You've said this person is guilty beyond a reasonable doubt. You can't find people guilty unless you find it's beyond a reasonable doubt. Once you've done that, then you get to the penalty phase where you have to choose between life without the possibility of parole and death. State puts on aggravators, defense puts on mitigators. You're required to listen to both with an open mind. You have to consider both sentences, weigh the aggravators and mitigators, and then you vote either life or death, depending on what your personal belief is that the appropriate, of what the appropriate sentence is. Do you understand how this works?
Yes, ma'am, I think so.
All right, so with that understanding, Ms. Miller, you may continue.
Thank you, Judge. I wanted to make sure when you were talking about mitigating circumstances, you weren't meaning if I had some doubt as to whether he's guilty of the crime. Does that make sense?
Yes.
Okay, so that's where back, if he's guilty of the crime, beyond a reasonable doubt, no defense, is death the only penalty?
I would say no.
Okay, why not?
I would have to consider, I understand where we're at in the process. Maybe I'm just not explaining it correctly. I think at that point we would have to weigh the mitigating factors against the aggravating factors to decide which one would be most appropriate.
Yep, and that resuscitation of the law, right? And if you are selected as a juror, the judge is going to give you all those instructions in writing. She'll go over them much more exhaustively, and no one has any doubt of your ability to follow the law. That's why we have this conversation now about your feelings, because some people say, I hear that and I have no problem with what the judge is telling me, And some people say, I hear that, but that's just inconsistent with my core values. Does that make sense?
Yes, ma'am.
So do you have any problem being able to follow that law?
No.
The effects of racism, do you think that you could give that on the defendant? Do you think that you could give that meaningful consideration? And by that, I don't mean I've heard it and then I've, equally dismissed it as it's going in one ear and out the other ear. Meaningful consideration means that it could possibly compel you in what you believe the appropriate penalty is.
No, race would have no factor in what I would decide.
Okay. How about the defendant's background or upbringing, if he had a tough childhood? Do you think that would be something you could give meaningful consideration to in the same way I asked you the first question? Not just I've heard it and then I've dismissed it. It could possibly compel you as to what penalty you think is appropriate.
I would say yes.
Okay. And that you see is different than the effects of racism?
Yes, ma'am.
Okay. This is not going to surprise you. 12 people often have differences of opinion on these sort of things, whether somebody lives or dies. And the law's okay with that. It contemplates that. With me?
Yes.
And that's why death is never required, not in any case, not in the worst conceivable case you can imagine. Still with me?
Yes.
And that if one juror decides that life should be the verdict, then life will be the verdict. Okay with that?
Say that again, I'm sorry.
So all 12 people would have to agree that death should be the verdict for the death penalty to be returned. But if one juror says life should be the verdict, then life is the verdict. With me?
Yes.
Okay. Mitigation, we throw that around a bunch. It's why any one juror would choose life or not choose death. And it doesn't have to be unanimous. That is, all 12 jurors don't have to agree on it. It can be unique to each individual juror. And it can be even something seemingly small, like a smile observed between the defendant and his mother, and that juror says, I give that the weight of life, and I'm just not imposing a death penalty in this case. With me?
Mm-hmm. Yes.
And in order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments have to be heard in this courtroom, right? There's one foreperson who writes down the verdict. That foreperson's job is to make sure that all 12 individual moral assessments are being reflected on that verdict form. With me?
Yes.
And that if all 12 jurors' individual moral assessments aren't heard in this courtroom, it would be a miscarriage of justice. And it's your duty, your right, and your responsibility to make sure your individual moral assessment is heard in this courtroom. Can you do that?
Yes.
You're not going to let anybody bully or badger you to changing your opinion?
No.
And you wouldn't do that to another juror?
That's correct.
A moment, Your Honor.
Yes, ma'am. All right, let me see the attorneys at the bench, please. We'll be right with you, ma'am. All right. And we really appreciate you coming in and your time and the attention you've given all of this. I'm going to excuse you as a juror in this cause. You're free to go.
Okay.
Thank you.
Thank you.
I see the juror in seat number 9, please. We good? Good afternoon, sir. How are you?
Good afternoon, Your Honor. I'm doing well.
I have a few questions for you. There aren't any right or wrong answers. We're just trying to find out if you can do your job as a juror. That's what these questions are meant to figure out. So we would just really need you to be honest with us and tell the truth. Don't worry about what the answer is, okay? So let me start by asking you, you indicated that you had heard about this case. Is that correct?
Correct, Your Honor.
And that you had formed an opinion as to whether or not Mr. Loyd was guilty based on that. Is that correct?
Yes.
And what is that opinion?
My opinion is from what I've seen, is that he is guilty.
Okay. Jurors must begin trials by assuming Mr. Loyd to be innocent until proven guilty. Can you do that, or would you start the trial assuming he's guilty?
It would be very difficult. In my position, I have a kind of a personal connection with the case.
Which is?
My mother served on a board with the victim. Served on she was appointed to a board with the victim and followed it very, very closely.
She served on the board with Lieutenant Clayton?
Yes.
All right. Thank you, sir. State.
State moves, Your Honor.
Any objection? All right, sir. This isn't the case for you. We appreciate you coming in. You're excused. Thank you.
Thank you, Your Honor.
Juror in seat number 37, please. All right, sir. Good afternoon. How are you?
Fine, thank you.
I have a few questions for you. There aren't any right or wrong answers, it's just the truth. Let me start with, you said you knew that you'd heard quite a bit about this case. Is that correct? All right, and that based on that, you'd formed an opinion as to whether or not Mr. Loyd was guilty. Is that correct?
That's correct.
And what is your opinion?
Guilty, Your Honor.
All right, do you believe that you would be able to set that aside and presume him to be innocent until and if the state proves he's guilty?
No, Your Honor. I've seen extensive coverage and have extensive information on the case.
All right. State?
State moves, Your Honor.
Any objections? All right, thank you, sir. You're free to go.
Thank you, Your Honor.
Thanks. All right. Juror in seat number 4, please. There we go. Good afternoon. How are you?
I'm good.
I know this can seem a little intimidating. Everyone's looking at you. Try and relax. Okay. The good news is we don't grade your answers because there aren't any right or wrong answers.
Okay.
The whole point of this is to figure out if you were chosen for this jury, could you do your job as a juror? Could you follow the laws of the state of Florida? And that's why we're asking you the questions. So what we really need is for you to be very honest with us, very open. Don't worry about what your answer is, just tell us the truth. We need to know what it is you actually think, all right? So let me start by asking you, you indicated you didn't know anything about this case, is that right?
That's correct.
All right. Do you have any problem serving and being sequestered for 3 weeks?
I'm just worried about next week. Like, do you know when it's going to start?
I do not, ma'am. I wish I did, but I do not. But next week, it might. What's going on next week?
Well, I'm covering for my father while he's out of town for vacation. He's self-employed, so I do his job and then my job at the work.
All right, so your dad's self-employed, so if you don't cover for him, is there someone else that can cover?
No, I'm the only person.
And how does that financially affect the situation?
Well, then neither of us will make any money.
So neither of you will make money? Is that money that you're going to make, is that necessary for you to pay your bills?
I mean, my husband can help. So, I mean, I think it's just like, if it was just me, it wouldn't be so hard of a decision to make. I could say, oh, I'll be okay, but because it's him too, so it's a little bit harder.
Okay.
Yeah.
All right, let me ask you a few questions about the death penalty. Do you have any moral, religious, or personal objections to it?
I just think that it would be a hard decision to make, not an easy one.
It would be. It's not supposed to be easy, honestly. Do you have any objections to the death penalty?
No, only just it would be hard. It just has to be under the right circumstances.
Okay. As I told you all, there's no automatic death penalty in the state of Florida. The automatic sentence is life. But in certain circumstances, when the state can prove aggravators beyond a reasonable doubt, then death becomes a possibility. You never have to vote for death, but it's a possible sentence, okay?
Gotcha.
Is the fact that this involves a police officer, does that sway you one way or another without hearing anything else? Just, it involves a police officer?
No.
All right. The way this works, because folks seem to be getting a little confused about this.
Okay.
In the guilt phase, the jury has to determine beyond a reasonable doubt that someone is guilty of first-degree murder before we ever get to the question of life or death. And first-degree murder is the intentional killing of another human